for his vehicle, Lordship, that order, Lordship, we will find on page 24, Lordship. That was rejected, Lordship, only considering that, Lordship, the order, Lordship,
My lord,
that last location also report called for.
last lordship was pleased to call for a report from the IO, my lord. Regarding today, I have received one report regarding not the Zimma, my lord, but received one information charge sheet submitted in this case, my lord.
What is the connection with the charge sheet? Because the charge sheet is that is for the accused, Lordship. Now it is for the Jima of the vehicle, Lordship. He is the register owner, Lordship. I annex that, Lordship.
Then we will have
Registration.
again call for the
Lordship may allow this.
Shall I, now charge sheet has been submitted, you can apply.
my lord before the court below also then we apply. For
That was
Pass an order accordingly, or should I call for a report regarding it?
if such an observation, Lordship, given, then I can approach again before the court, because that was already rejected. Now, Lordship, on the ground, Lordship, is a premature stage of the investigation. That's why
that's right. That's right.
now, Lordship,
Charge sheet
now
submitted.
charge sheet submitted, that means investigation is over, Lordship. So Lordship may release
Remand it
the.
back.
Yes, Lordship.
They may also approach for the court.
Lordship can Lordship allow this petition because it's the vehicle, Lordship.
You will need a report.
Short date, Lordship. There was because charge sheet has submitted, and there kindly peruse that, Lordship, the order that is 24 and page 26 is the relevant portion. May I read that?
Harm in heading over the vehicle. That petitioner is on bail. So where is the problem? But you see, I'll need a report at least.
So in the
A short date, Lordship, from it's not Guwahati.
If report as called for is not received, call for the, it is submitted, Mr. BM Chaudhary, no?
B. Chaudhary.
B. Chaudhary is present for the petitioner, Mr. B. Additional Learned Counsel, Mr. Rudhyate Learned Counsel, Learned Additional PP, Mr. B. Sama is present for the respondent state and has submitted that. The report has not been received, but the IO has submitted a report that circuit has been laid against the petitioner. Post of call for a report relating to the Jima of the vehicle seized in connection with this case. A list on
Lordship, last date, last chance, Lordship. They have taken the
a last chance is according to the prosecutor to produce the report.
highly obliged. Lordship.
Kindly pass over to my family. Pass over for timely.
All right.
My lord, here also, my lord, my prayer for Jima of the vehicle was rejected by the learned court below. Lordship will kindly have a look at the FIR, my lord, page 16, my lord.
We'll call for a report.
my lord.
My lord, only thing is
It's a
this.
pass.
But
Bas, kindly see,
report.
kindly see the report, my lord. Kindly see the rejection order, my lord. Once, my
So
lord.
what is the point? I'll need the report.
46, my kindly bear with me.
What is the point?
Lordship, I will read the rejection order. IO submitted the Jima report stating as per record, the owner of the seized vehicle, so and so, is Himanshu Pathak, petitioner. 46 page, my lord. But the IO submitted the seized vehicle may not be handed over in Jima as forensic expert's report. What is the role of forensic expert here? MBI report is already, I have taken with the petition, my lord. Page 39.
What is the section offense?
Offense is, my lord, unfortunately, the lady died. Who made it?
See, nowadays DNA is lifted from seat,
No, I
bus
understand.
seat,
I understand. my lord.
mattress,
I understand.
carpet, everywhere, from everywhere DNA is lifted nowadays. So forensic experts have become very skilled now.
No, my lord. This is an accident case. The vehicle, the scooty by which.
Accident case.
Yes.
But
Lordship will kindly see.
you have just said one lady has passed away.
She met with the accident and unfortunately she died. That's why. Case 39, Lordship will kindly have a look. The MBI report.
We are not asking for
But-
forensic report. We'll just ask for a
Report, whether it is-
to
No, my lord, if
Jima
my lord,
vehicle.
what I am submitting, my lord, if my lord, again, this sort of report is submitted before this court,
No, we'll go to, if it is only about accident,
my lord,
I don't want forensic report.
that
We
is
only
why,
want
my lord,
report whether
that
it can
is why,
do
my
it.
lord,
what is this required of further investigation?
what further investigation they will do with my vehicle? Lordship will kindly see. FIR, Lordship will kindly white color Volvo bus. Case 41, Lordship will kindly see the photograph of the bus. It is a blue color bus.
Please, let's not waste time.
My lord,
My lord.
I understand, my lord.
Report relating to the Zima
Baba.
vehicles is in connection with this case. List the matter on
Friday, my lord, Friday, my lord, kindly, Friday. Because I am paying,
11th, my lord. I will have to send message also, my lord. then.
on
this is
11th.
Godchuk, my lord, Godchuk,
On 11th.
Godchuk, my lord. Kindly, my lord, because I am paying monthly installment of rupees 10 lakh,
9th on 9th.
9. God bless you.
Praise the Lordship. Lordship, this is a criminal revision petition, my lord. Hereby we are challenging the order of the learned court below, that is District Session the Sojai, my lord. At first, kindly see the page 23, my lord, my petition. My lord, page 23, bottom side, two defense witnesses are present. Got it, my lord?
Hmm.
Seen petition number 4117/2018, filed by the, it should be 2024, my lord, wrongly 18. Accused Anjan Sahu, wherein he has prayed to allow recording his evidence as defense witness. The prayer is allowed during examination in chief. The witness, that is DW1 Anjan Sahu, suddenly fell down and he was not in a position to adduce his evidence due to his illness. Learned counsel for the accused has prayed for another date for defense evidence due to his medical condition. Considering the matter and its entirety, the case is adjourned for today. Step has taken for sending the witness to hospital for his treatment. Another defense witness who appeared before this court is the wife of accused. She has to go hospital for caring his husband for his, she cannot be examined today. My lord, for this reason, on that day, the defense witness, both the defense witness are not examined. Now, my lord, kindly go to the page number 39. This is the admission cum prescription of Guwahati Medical College and Hospital, dated 12/10/24. 18/10/24. He was admitted before the at the GMCH, my lord, and thereafter, doctor of the GMCH advised him to for better treatment. Then, my lord, kindly go to the page 25, my lord, annexure 6. This is train ticket. He has went to the Chennai for his treatment on 20/2/10/24, my lord, and he was admitted to the Chennai on, my lord, 27. Since page 41, my lord, 27/10/24, he was admitted in the Sri Ramchandra Medical Center, Chennai, and since then till 24/4/2025, he was admitted there.
From 27/10 till 24/4.
My lord.
24/4. This is a long time. My lord, kindly see the
Only
page
time is
46.
granted by the court below. Lordship, may
Kindly see the page 46, my lord.
24/4.
There,
April.
kindly see the page 46, my lord. Current status, that is 22/11/2024 dated. Hemorrhagic stroke, hemorrhage in the brain, admitted in the hospital in critical condition. Treatment will continue till recovery.
Okay.
His injury is much more serious, my lord. And how he sustained that injury while he attended the adduces evidence in the witness box. After some time recording his statement, he was allowed to sit in the chair within the witness box. And while chair was given to the witness box, there was stairs, and while he sit down on the chair, suddenly he fall down the back and he sustained head injury. And for this reason, my lord, he was admitted to the hospital. Thereafter went to Chennai for his treatment, my lord. Now kindly go to the page number 36, my lord. This is the impugned order. A long order. I will read out relevant partners. 36 on 4/10/24, my lord. From top side, my lord. Got it? Page 36, 120, 41024.
My lord, it is also easier for us, my lord. We will have to read it from. It is better to read from the first, my lord.
My lord,
25.
I'll
Then
long order. That's why I'm trying to read out on the 11 part. My lord. Page 35, my lord.
Hmm.
Accused of Bhanuram Sahu and Anjan Sahu were absent. Pair is allowing their absence has been made by filing petition number 60525 and 60625. The case is fixed for defense evidence of Anjan Sahu and his wife. Learned public prosecutor filed petition number 604/25 saying that after closure of prosecution evidence, statement of defense of the accused person under section 313 CRPC were recorded on 27/2/2020. But accused person did not adduce any evidence, and so the court fixed the case for argument on 19/1/21. Accused person moved before the Honorable Guwahati High Court. Honorable Guwahati High Court allowed them to adduce evidence, but the accused person did not adduce any evidence in next 24 dates. That is 1/3/21 to 8/7/24, and therefore the evidence of the defense witness were closed for the second time, and the case was fixed for argument. The accused persons for the second time moved before the Honorable Guwahati High Court, and the High Court issued direction single opportunity to accused side for examination of 3 DWs and first direction not to grant further time. On 4/10/24, accused Anjan Sahu and his wife were present, and he was examined in length in the beginning by defense side for about 2 hours. His examination in chief during which he fell ill. He fell ill could not be completed. But thereafter, the accused person Anjan Sahu remained absent for consecutive 7 days. After the sustain of that injury, my lord, he was remained absent 7 days. And why this 7 days he was absent, I have stated earlier, my lord. He was admitted in hospital from Guwahati to Chennai, my lord, for a long period of time. And
These are the 7 days.
7 days. Yeah.
And then what about the
earlier 21, my lord. Total
Earlier long date it was given by for that different reason he was taken adjournment, but Honorable High Court allowed that adjournment, and last chance was given to adduce his evidence. And after getting this last chance, he accordingly all these 3 witnesses appeared on the same day for recording their statements. But unfortunately, he was fell down from the witness box and suffering head injuries. And due to that injuries, he was unable to record his statement. I'm praying on that medical ground, my lord, he may be allowed to adduce his evidence on the next day.
third
And-
time, my lord, it will be
My lord,
third time.
this third time was happened. This is unfortunate due to some unfortunate event, my lord. This is not intentional. So I'm humbly praying before this honorable court. He may be allowed to adduce his evidence, and issued NBW against him, that is maybe suspended, my lord.
My lord.
why you are stretching the case so much?
My lord, he is the accused person, my lord. Main
Accused in
accused person.
unfit section.
302 is there. 302.
This way.
My lord. My lord, page 36, my lord. And the accused side all total took 35 deaths.
Including this 7 days.
W
Earlier,
that is 15 to 2021 to 25 to 2025, covering a period of 4 years for adducing their evidence, causing great prejudice to the victim and their family members. My lord.
Hello.
The accused person intentionally misused law, and therefore he prayed for closure of defense witnesses. My lord.
my lord. Earlier,
4
whatever
years,
may
my lord.
happen,
Third time they have come here, my lord, for
my lord, earlier, whatever may
adducing
happen,
DWs, my lord.
Honorable High Court allowed him on grant him last
The
chance.
last occasion.
But last chance, he was unable to comply with that last chance due to some unfortunate event. He complied with that last chance. He accordingly appeared before the witness box, and suddenly he fell down from the chair, my lord.
Yeah,
That is the reason.
After 7 consecutive days.
My lord, 7 consecutive days.
The chair.
My lord, he was fell down.
Broken?
My lord,
Was the chair broken or something like that?
I'm not aware about
Was
that
a
part.
portal chair.
But that is written in the order, my lord. He has fell down from the witness. My lord, last chance, my lord. My lord, last. My lord,
See, that was unfortunate. That same day he went
my lord.
and then he has documents also.
My
My lord,
Check,
here,
get,
here, Lordship, it is also made clear that and further no any chance may be given him, my lord. Only 3 times he is given by the Honorable High Court, my lord,
My lord.
to adduce his
That is
evidence,
maybe
and it is the offense
this is under which section?
302, my lord.
302 is there.
This petition?
This petition under section, my lord,
They have challenged the criminal, it is criminal revision, my lord.
immediate
Challenge
revision,
the order.
438, read with section 528, my lord.
How many times did you file the revision petition?
528.
Revision petition.
Revision petition 528, my lord.
Second time, third time.
This is a revision petition, not maintainable for enough time. You can file only once revision petition.
My lord.
482, okay, you can file, but you have inserted this revision.
Criminal revision petition.
This is a new order against the new order. Earlier, another order. From the same order, not where it were second time, third time. Against another order.
Against order or against the purpose?
Order,
Purpose
order.
is the same.
My lord,
No,
purpose is the
purpose is not same, my lord. This is, my lord, subsequent development, my lord.
Thereafter, my lord, 37, page 37, my lord. Page 37, my lord.
Yes.
Upon perusal of the record, we see that learned advocate for the accused Anjan Sahu never submitted any original documents in the last many dates. He only submitted current status report from Sri Ramchandra Hospital. It is clear that accused Anjan Sahu is not an admitted indoor patient as per his claim. The Xerox copy of the medical documents as submitted by the learned defense advocate is not inspiring confidence. The court considers that it was quite possible on the part of the accused Anjan Sahu to produce original medical documents in this case in the last 1 year or so, but they have failed to do so. The Xerox copies of the documents filed together with petition number so and so is not found believable in absence of other original documents in the case report. Hence, prayer for allowing the absence of accused Anjan Sahu is petition so and so also rejected. Considering the fact that medical treatment is also available for the accused in jail premises. Accused Anjan Sahu and his wife appeared for their examination in the court so and so, but they abused the process of the court. Thus, they fail to avail the single opportunity allowed by the Honorable High Court so and so. Hence, prayer for the learned public prosecutor so and is allowed. DW is closed. Bench assistant is directed is NBW against the.
My lord, at that time he was in Chennai. How he produced original medical prescription? my lord?
Now you have produced.
Now, yes, now I am available with my petition and annexed with my petition. my lord. Original are annexed with my petition. my lord.
These are Xerox copies.
All are those.
No, my lord, here is in my file. Original is in my file, my lord. These are with my petition, my lord.
Let me see.
That is nothing but the lingering the case, my lord. From 4 years, we have taken time, my lord, for DW.
Under any condition, my lord. Any strict
Argument is-
condition, last opportunity. my
Twice
lord.
it was fixed for argument, my lord, due to absence, my lord.
But at last
It is
incident,
nothing
it is
but the lingering the case, my lord.
last incident is very unfortunate, my lord.
Lordship may not consider their prayer at this stage, my lord.
Let us not joke with other.
He was he was undergoing treatment from 27/10/24 up to 24/4/2025.
Up to 25, my lord. Like 302 is there, otherwise she is seriously digitized, man. That's
Then be granted, I think. One last opportunity.
last one.
Third learned counsel, Mr. A.K. Azhar,
Take care.
for the petitioner. Anjan Sahu, who has filed this application under section 438, 442, read with section 528 of the BNWS 2023, challenging the order dated 25/4/2025 passed by the London Trial Court. Closing the evidence of TWs and issuing NPWA against the petitioner. Third, Mr. B. Sharma, learned election PP Assam, who has raised serious objections stating that the petitioner has been procrastinating this case and has procured several adjournments
Total 35 adjournment.
Huh?
Total 35 adjournment for last 4 years.
and has procured 35 adjournments for the last 4 years, preventing culmination of trial.
Well,
The petitioner is not entitled to any relief as he has preferred earlier revision petitions for adducing evidence, despite the fact that the evidence of the defense was closed by the trial court. Full stop. For contra, the learned counsel for the petitioner has submitted that this is the first time the petitioner has come against an order, against the order dated where is the order, page 25?
Pin order and pin order 35, my lord. 25/4/25 order dated.
Against the order dated 25
Or 25/4/25.
25/4/2025 and no earlier revision petition has been filed debarring the petitioner from preferring a revision against the order dated 25/4/2025 passed by the learned session judge, additional session judge in connection with sessions case number 5/2018.
My lord, sessions case number. Yes, case. 5, my lord, session case number within bracket 1/5/2018.
Sessions case number within bracket 1
Oh.
5/2018.
Mm.
It is submitted that earlier the petitioner was accorded opportunity to adduce defense evidence, but he had taken adjournments. But unfortunately, on uh, (25/4/2025), when the petitioner was accorded a last opportunity to adduce evidence by this court in connection with which case? Which case?
Session case number, my lord.
No, this court's case.
My lord,
This court's case.
session case number was within bracket 1/5/18.
You were given a last opportunity.
Yes. Oh, the High Court case, my lord.
Yes.
High Court order. I'm reading now. My file is there, my lord, so I'm this. My,
You can check I think these are originals. You can check the receipts.
My lord.
I think these are originals. At least it appears to me like originals.
my lord, revision petition number 336/24.
Which was preferred against order dated, which another case? Another order?
Order dated, my lord.
Criminal revision petition number 37.
Challenging the 1/8/24.
1/8/2024. The petitioner has annexed copies, Xerox copies of the. So you submit these copies, originals?
Prescriptions.
Yes.
Original, I have to submit before, I think, a trial court. If require further reference.
The petitioner has submitted copies of the documents of undergoing treatment due to brain hemorrhage and hemorrhagic shock in which Ramchandra, what is the hospital?
Ramchandra,
Sri Ramchandra
Sri
Medical
Ramchandra
Center
Medical Center.
at Chennai. The petitioner has also produced the originals for perusal. And to substantiate the Xerox copies submitted along with the petition and marked as annexure.
Annexure, my lord.
My lordship also kindly peruse the page 49, my lord.
Page 14.
Page 49, my lord.
Annexure 10 series medical papers.
Annexure 10 series. Page 49, yes.
49, my lord. Prescription, my lord. Tissue plasmic activation, TNK injection, clopidogrel, nitrogen 30, my lord. These are the my lord, medicines, my lord.
I don't have any idea. But that he has suffered from hemorrhagic shock, that is correct.
My lord.
Yes. But I don't have any idea.
My lord. Nitrogen, my lord, that 30, my lord. That is,
You will know.
I am also not known, but perhaps I have heard something. Whatever, maybe the lordship will call this further. There may be serious doubt about this also, but
Maybe. His NBW has been cancelled, no?
Well, now
His NBW has been,
should against.
NBW issued against him,
has been issued.
as he is not here for a long time. But
Page 38, bench assistant is directed to issue NDW.
He has been dismissed from medical bed
Well-
on 27/10 itself.
My lord. He released from bed, but his statement was going on. Treatment was going on, but he released from bed. Page 44, weekly checkup for expected recovery. That was, my lord, he was advised to.
No, it's okay. Other documents shows that he was taking treatment in the hospital itself.
My lord.
Even 22/11 also admitted in the hospital in critical.
Subsequently, again, he was admitted. My lord.
Annexure 10 series starts at page.
Start page 39.
Okay. Annexure 10 series लिख ला ना? It is further submitted that this court has wide jurisdiction under section 528 of the CRPC as well. Full stop. The
Medicine to
petitioner
disease,
will be highly prejudiced if he is not allowed to adduce evidence in defense. Full stop. It is further submitted that the petitioner was undergoing treatment in Sri Ramchandra Medical Center continuously since 27/10/2024 up to 24/4/2025. I have scrutinized the originals along with the Xerox copies of the documents. I find force in the argument of the learned counsel for the petitioner. It appears that a last opportunity may be accorded to the petitioner to adduce defense evidence. The petitioner is directed to appear before the trial court within 15 days and adduce his evidence and complete his evidence. On the same day itself, the NBW issued against the petitioner is kept in abeyance up to 15 days. Thereafter, you ask for cancellation.
My lord, my lord.
On the next date, my lord, next date fixed by the trial,
Which date?
When is the
Yes.
next date fixed?
Next date is fixed, huh?
that I am not at. Okay, within 15 days.
Within 15 days.
My lord.
Is it above beyond 15 days?
Actually, I have to check, my lord. 15 days I will enter, my lord. 15 days. He may be allowed from the previous bill, my lord. The direction.
This is not bail petition.
Bail is not the bail petition.
On the next date fixed will be better. I
My
think.
lord. Next date, my
On the
lord.
next
Next
date
date.
fixed
Next date.
and adduces evidence.
And complete their defense.
Who is the lawyer out there? He has to be prepared.
My
He
lord.
must no
I'll-
adjournment or should be granted to the petitioner.
Right.
No further adjournment should be granted to the petitioner. In terms of the above observation, these petitions get disposed of.
My lord.
Acha, good.
May I please? Sir?
Hmm.
Also kindly see page 30.
Hmm?
Page 30. Petitioner was convicted for a period of 3 years, lordship, under 325. Page 30 may be seen third paragraph.
Okay,
Page 30.
enact.
No, lordship. 325.
326, 307 is there.
Thereafter, lordship, we have filed appeal before the sessions of
Again convicted.
being convicted
Sentence.
modified and reduced to 2 years.
2 years.
Against which we have filed Meanwhile, Lordship petitioner also surrendered. Lordship. Court directed to surrender within 14 days. He already surrendered. Now he is in jail.
Yes,
My lord. My lord, he was convicted under section, my lord,
Just 63.
rigorous imprisonment for 3 years, my lord, in the appellate court, my lord.
Just 33. That it was
can be granted, no?
My lord, 3 years, my lord,
Bail and suspension.
my lord,
3 years can be granted, no?
my
Also,
lord.
we have 2 years here. Now we have against which we have 2 years.
It was earlier 3 years, my lord.
Earlier 3 years. Now
Where is the section in BNSS? Now it is got lowered down to 3 years, enhanced to 3 years.
Fine.
Okay, then let him place his objection
My lord.
if he has any objection.
the point of conviction is 2 years, Lordship. Here, Lordship may grant a suspension.
2 years, but this is 3 years.
No, Lordship, 2 years.
Automatic. This is 2 years.
2 years. We have
Oh, now it has been
reduced
Reduced
to 2 years.
and your conviction to 3 years.
Earlier 3 years. Now reduced to 2 years.
Yes.
Against which
But you are convicted to 3 years.
earlier 3 years, now 2 years in the
Oh, now you.
Appeal, in appeal, it was reduced to 3 years.
So what about the sections I'm asking?
325.
325.
No, that
At that time, 325.
automatic bail,
Yes, Lord. We have and
the 3 to 89 vis-a-vis that new
yes,
section.
Lordship. Yes.
Uh.
That is 430.
How much?
Now in BNS 400, 430. 430. Suspension of sentence.
Yeah, the 3 years in liquid.
Yes, it is for the previous.
3 years in liquid. What did that go? Appellate court of judgment. Into well, at page 45, my lord. Kindly page 45, my lord.
Of IA or this appeal memo? Revision. IA or revision?
I am, my lord. Regarding the conviction, my lord. 5, my lord, paragraph 5, my lord. Lord, with regard to the sentence of 3 years RI imposed by the Land Trial Court, I find that the accused appellant is a senior citizen and some leniency can be shown in respect of the penalty to be imposed. Accordingly, the period of RI is reduced to
Okay.
3 years. my lord. Previous bill,
No, I'm not good. 14 days is a total of last.
Yes, your lord.
They don't
But land responsibility it is for the applicants.
He'll have to go to fresh bill, man. As he has surrendered before the court, he will go to
fresh bill.
fresh bill, man.
Yes.
Fresh bill.
Up to Lucien Bhuiya, who has filed his application under section 430 of the BNSS 2023, which pray for suspension of the execution of the sentence passed by judgment and order dated 29/4/2025 by the learned session judge Kamrul Guwahati in criminal appeal number 67 2023 upholding and modifying the judgment and order dated 31/8/2023 passed by the learned Judicial Magistrate First Class Kamrup M. Guwahati in GR case number 13171 of 2012, whereby the sentence of 3 years of rigorous imprisonment under for conviction under section 325 RPC is reduced to a sentence of 2 years of imprisonment, and the fine has also been reduced from rupees 7,000 to rupees 500 with default stipulation. Third, learned additional PP Mr. B. Sharma for the respondent state for the respondent number 1. Full stop. I have considered the submissions at the bar. It is submitted on behalf of the petitioner applicant that he has a good case of acquittal. Full stop. Considering the submissions, the petitioner is allowed enlarged or bail of rupees 30,000 with a suitable surety of like amount to the satisfaction of the learned trial court.
Right.
In terms of the above observation, this begins stands disposed of.
Right.
The operation of
appeal,
the operation of the impugned judgment and order dated duitai likhi diba. Criminal appeal is stayed until further orders. In terms of the above,
Oblige.
this shall I issue notice to the respondent to
Well, notice admitted and call for the
admit it and call for the
Okay.
records. Respondent one only, one respondent, or you have arrayed the complainant also,
Complainant. no.
Well,
complainant also.
the notice will go.
Petitioner, head petition is Learned Counsel Mr. A.T. Petitioner, Ekatol Kitwa B. Sharma. Petitioner takes steps to issue notice to the respondent number 2, as per usual process, returnable within 4 weeks. 4 weeks.
Right.
Call for the records of criminal appeal number so and so, or very appeal the GR case number so
GR
and
case.
so. List according.
Right.
Right.
Item 13, pending item 13.
Yeah, please, Your Lordship. Lordship, this petition has been preferred due to imposing of a bank guarantee, Your Lordship, due to imposition of a bank guarantee, Your Lordship,
Okay.
on the event of releasing of a truck vehicle, Your Lordship, which has been seized, Your Lordship, in a case registered under section 11 and 13 of the Assam Cattle Preservation Act, Your Lordship. The judgment is, Lordship, at page number 21, Your Lordship. Order, Your Lordship, not judgment. The relevant portion, Your Lordship, at page number 22, Your Lordship. The first portion, Your Lordship, I'm reading the portion, Your Lordship.
All right.
Considering all the in the view of the report of the IO, the Jimma petitioner, namely Rustam Ali, is allowed to take the interim Jimma of the seized vehicle bearing registration number so. After the IO, does the following: makes proper verification of documents of the petitioner in regard to his ownership of the aforesaid vehicle, obtains appropriate color photographs of the aforesaid vehicle from various angles, and obtain a bank guarantee of rupees 60 lakhs from the petitioner. That is my grievance, Your Lordship. So I prefer this petition, Your Lordship, for modification of that part, Your Lordship, so that I am ready to execute any bond, Your Lordship, equivalent of
Cattle Trespass Act, I think.
Well, there is a provision also.
there is a provision, Your Lordship,
For
yes,
bank
but
guarantee.
Your Lordship, if Your Lordship permits me in that regard, Your Lordship, may I get the attention of Your Lordship to section 11, subsection 5, Your Lordship.
Oh, yellow color. Which one? Section?
Section 11,
11,
section
subsection
5
5.
of the Assam Cattle Preservation Act, Your Lordship. I'm not reading the whole paragraph, Your Lordship, just one word, Your Lordship. Your Lordship, on receipt of the report, may I read the portion, Your Lordship?
No, getting the act.
Your
Just
Lordship,
a moment.
yes, Lordship.
Okay. Yes.
That is paragraph number, subparagraph 5, Your Lordship. On receipt of the report, the judicial magistrate first class may, on his being satisfied that there is enough material to presume that a prima facie offence under this act has been committed or intended to be committed, release the seized materials, including vehicle, conveyance, except cattle, on furnishing of a bank guarantee. Now, Your Lordship, the word may is sufficient to denote, Your Lordship, that the part is not mandatory, Your Lordship. The imposition of the bank guarantee is not mandatory, Your Lordship, that can be discretionary, Your Lordship. Now, if Your Lordship, the provision, Your Lordship, for the same has been enumerated in section 497 and 503 of the BNSS, Your Lordship.
Okay, yes.
My lord, here, I don't find any illegality in the order, my lord, passed by the court below, my lord. As per provision of the, my lord, lordship already found that, my lord, section 11, subsection 5, my lord, it has bank guarantee was given for release of the, my lord.
For that reason, also, I'm coming to some submission, if Your Lordship allow me to submit, Your Lordship, on that regard, Your Lordship.
This is revision petition.
Revision,
Revision petition.
What is the impropriety? You have to show the
my lord,
impropriety.
Hmm.
Where is the wrong?
my lord.
Your
Up to
Lordship,
you.
I have pleaded that my grounds, Your Lordship, that things, Your Lordship. Therefore, Your Lordship, I would like to place that submission, Your Lordship. Here, Your Lordship, if Your Lordship, the same thing, the same procedure to release a vehicle or any articles, Your Lordship, encoded in BNSS also. It is under 497 and 503 of the BNSS, Your Lordship. Now, if Your Lordship kindly come to section 497 and Your Lordship 503 of BNSS, that is procedure, Your Lordship, for releasing of a article, seized article, Your Lordship. That article, Your Lordship, that section, Your Lordship, doesn't speaks about, Your Lordship. Lordship, that provision, Your Lordship, that procedure doesn't speaks about the Lordship imposition of the bank guarantee, Your Lordship. That provision, that procedure speaks about, Your Lordship.
No,
That-
no.
But it is a
But
special,
this
I'm coming to the
speaks
subsequent.
about.
it is a
Yes, Lordship.
special act, my lord, but
Lordship,
there is a
Lordship,
specific.
for that reason, also, I'm coming to that, Your Lordship. For that reason, Your Lordship. Yes, I can understand. This is a special enactment, Your Lordship. That is the enacted by the state legislature, Your Lordship. Now, if Your Lordship kindly see the 497 and 503, that is the act, Your Lordship, enacted by the Parliament, Your Lordship. Now, Your Lordship, article, Your Lordship, Your Lordship, kindly come to 48 of the Constitution of India, Your Lordship.
No, no.
Where, Your Lordship, repugnancy, some
Right.
inconsistency are there. Yes, there, Your Lordship.
Where is
for
the-
that-
where- what is in your petition?
Yes,
Let me
that
see
grounds
your
are there.
petition.
That grounds are there, Your Lordship. I have pleaded in my grounds, Your Lordship.
Any financial conditions?
Yes, that I have
Mind
pleaded.
little things.
That
We
I
don't
have
have to
pleaded,
go to
that
the-
I have pleaded, Your Lordship, because of the financial condition, because the 60 lakh rupees imposing bank guarantee is a very excessive amount, Your Lordship. The person is not in a position to submit that amount, Your Lordship, in the bank, and bank will refuse to issue that bank guarantee on that event, Your Lordship. So, Your Lordship, due to that harness, Your Lordship, I prefer this application for that modification, Your Lordship. So, is the discretion is there, Your Lordship.
And
Otherwise,
what are your grounds on the petition?
Your Lordship, the Sundar Bhai case also I have pleaded in my ground, Your Lordship. And again, Your Lordship, due to harness, Your Lordship, my financial hardship, Your Lordship. And due to if Your Lordship kindly come to RC, Your Lordship, it is a space number 20. It was already financed by Chola Mandalam. The EMI is going on, Your Lordship. So it itself reveals the financial hardship of the petitioner, Your Lordship. And Your Lordship, for that reason, Your Lordship, otherwise, Your Lordship, for the procedural part also, I have pleaded in my ground, Your Lordship. But I have submitted, Your Lordship, some subsequent things is also I have pleaded in my grounds, Your Lordship.
Okay, then. 60 lakhs, it's not possible for everybody to bank that much of money in the bank.
Perhaps court below also considering the value of the cow and value of the truck also, my lord. Truck also.
Is another spat that was not
That's why,
Solvent person, so with surety,
which
My lord?
is Lordship.
surety of any other solvent person, land document.
my lord.
Lordship, I'm ready for that, Your Lordship. The interest of justice, Your Lordship. Is it?
Which paragraph you have mentioned about his insufficient funds,
Lordship.
doesn't have sufficient funds? Which paragraph?
Doesn't they?
Yes, Lordship. 6 number paragraph, Your Lordship, at page number 5, Your Lordship. Seven is also relevant, Your Lordship. I have pleaded that thing also, Your Lordship. I'm ready to deposit the landed documents also. In this so.
Third, Ms. P. Borano,
Your Lordship.
Bora, learner counsel for the petition. Rustam Ali, who has filed his application under section 438, 442 of the code of the BNWS 2023, with prayer to recall as well as modify the order dated 24/3/2025 in connection with Portador PS case number 26/2025 under section 11/13 within bracket 1 of the Assam Cattle Purification Kua, the bank guarantee of rupees 60 lakhs. It is submitted by the learned counsel for the petitioner that while the order impugned, the learned judicial magistrate first class at Nagaon directed the vehicle bearing registration number AS13 AC 6465 to be released in favor of the petitioner subject to furnishing a bank guarantee of rupees 60 lakhs. Third, Mr. B. Sharma, learned additional PP Assam. Stop. I have considered the submissions at the bar with circumspection. It is submitted on behalf of the petitioner that the petitioner is not in a position to deposit an amount of rupees 60 lakhs as bank guarantee. Post up, he makes a living out of car rental business. And he is not financially sound to furnish security in the form of bank guarantee of rupees 60 lakhs. The petitioner is willing to furnish security, any other security, any other suitable security except bank guarantee. The learner additional PP has submitted that the order is not liable to be set aside as the order has been properly passed. I have considered the submission. Learned counsel for the petitioner who has relied on the decision of the Honorable Supreme Court in Sundar Bhai Abalal Desai versus State of Gujarat 2022, reported in 2022-10, so SCC 283, wherein it has been observed that paragraph 6, italics of Likhakini, paragraph 6, page number 6, paragraph 6, page number 6, petitioner, italics of Likhakini. It is further submitted that the vehicle has been lying in the open and is getting damaged since when?
Lordship. That was 29 February 2025, Your Lordship.
I have also, considering all aspects and in the light of the decision of the Honorable Supreme Court in Abalal Desai, I deem it appropriate to modify the order for the bank guarantee. Full stop. The bank guarantee of rupees 60 lakhs. For the bank guarantee of rupees 60. The order dated 24/3/2025, so far as the bank guarantee is concerned, is modified, and the petitioner is directed to abide by the other conditions imposed upon the petitioner while taking custody of taking Zimma of the vehicle bearing registration number AS 13A C 6465 on furnishing to suitable surety of rupees. So, suitable surety, will you be able to furnish suitable surety of 60 lakhs? Yes, rupees 60 lakhs.
60 lakhs will be excessive, lordship. Lordship, that can be modified to 60 lakhs is very excessive, will be lordship.
Maturity.
Land surety
Yeah.
to the satisfaction of the suitable surety of rupees 60 lakhs instead of bank guarantee of rupees 60 lakhs. Or to the satisfaction of the who is to suppose take
The police is the IO, your lordship.
to the satisfaction of the IO. In terms of the above observation, this petition stands.
Due respect, lordship, with one another prayer, lordship. Instead of 60 lakhs, lordship, equivalent value of the vehicle, lordship,
But there were cows also in the bank.
is also.
I think he'll be able to find. I'll come back after 5 minutes.
22/11/20.
You have the report?
A report of 50. This court is deemed fit, then last line of the report of Sarsit Sabri court is deemed fit, then MD can do the
All right then. Is the IO, no?
IO.
Should I direct the IO or the OC to hand over the vehicle? Because Sarsit has been submitted and everything has been given to the file, CD and everything is given to the
in the court.
court and the Thana.
Okay.
OC will better, no? What Learned Counsel means?
He asked for
He asked for the petitioner who has filed this application under section 4. Five 528. Of BNWS 2023 with prayer for Zimma of the vehicle bearing registration number AS 12CC 1072, a Bolero pickup FBPS 1.3T. The petitioner is agreed by the order dated 13/3/2025 passed by the learned special judge Udalguri in connection with petition number 381 of 2025. Rejecting the Jimma of the vehicle seized in connection with Rauta PS case number 128 of 2024 under so-and-so sections. At Mr. D.P. Goswami, Learned Edition, PP Assam. A report has been sent from the IO, who has submitted that charge has been laid against the petitioner. being CS number 49 of 2025 under section 2020 within bracket small b within bracket 2 within bracket capital C stroke 29 of the NDPS Act dated 1/6/2025. The investigation is complete and the vehicle is not required for further investigation. The earlier impugned order was passed at the stage of investigation as the vehicle was required for further investigation. Full stop. Now the IO has submitted a report that the vehicle is not required for further investigation. The vehicle may be given in Jimma to the aforementioned vehicle may be given in Jimma to the petitioner. On his execution of a bond of rupees 1 lakh, 1 lakh to the satisfaction of the OC with an undertaking that the petitioner shall produce the vehicle as and when required by the court. Any other condition?
And then when required,
As and when
proper to investigation.
the report of the IO will form a part of this order. In terms of the above observation, petition stands disposed of. Item 17.
May I please your lordship? Lordship, this petition is filed being aggrieved by a FIR lodged by the respondent number 2, which your lordship will find at page 24.
Page 24.
Page 24, that is annexure 5.
Okay.
Now, the respondent number 2 who has lodged this FIR also happens to be a public information officer in the Assam Seeds Corporation Limited. Now, she has filed this FIR, and if I may read, I so and so presently serving as the administrative officer at Assam Seed Corporation so and so. And after Guwahati 22, lordship will find since last 10 years, it is within parenthetical commas, want to lodge this FIR against Mr. So and so, one of the vendors of so and so. On 9/4/2025 at approximately 4:30 p.m., so and so unlawfully entered my office chamber without permission. He instructed my subordinate to vacate the room and aggressively demanded that I process file number so and so relating to his pending GST reimbursement. I informed him that the file could not be processed due to absence of essential corroborative documents that were previously submitted with the original bill, but were no longer found in the file. These documents are crucial for further processing and approval. In response, so and so attempted to offer a bribe of rupees 50,000 to influence me to forward the file with a positive note. Despite the missing documents, I categorically rejected the offer and asked him to leave the chamber immediately. Instead of complying, so and so became aggressive and verbally abused me, and thereafter some allegations are there, which I would not like to read out before this honorable court. Now, the prelude to this FIR, are two RTI applications which I have filed before the Assam Seeds Corporation seeking some instructions, which your lordship will find at Annexure 1. Annexure 1 is the first RTI, which your lordship will find at page 18. Now, after filing this RTI, the information was not given to me. I preferred a first appeal. That was also not lordship entertained. Then I preferred a second appeal. There was a direction in the second appeal to give me the information within 10 days. Since this information was not given, I filed a complaint before the Assam Information Commission. And the Assam Information Commission passed the order dated 25/3/25, which your lordship will find at page 19, directing that I be given the information and within 7 days, and the matter was fixed on 23/4/25. I filed another RTI, and the same RTI lordship has received the same fate before the respondent authorities, and in that RTI also, the date was fixed on 23 because I had filed the complaint. And the day before lodging of the FIR, because lordship RTI, what happens is the applicant, he also discloses his phone number.
Hmm.
I was informed to collect the materials from the office on the next day, that is 9th, in the second half. I went there in the second half. I was given certain documents, but those were not legible. I said, I cannot receive these documents because not legible and it is without any forwarding letter. She got annoyed. Then she asked me why I had lodged a complaint before the chief minister. Now, why I was pointing out in the FIR that I wanted to lodge this FIR from 10 years, there is a story to that. In 2017, through RTI, I had got certain information. This particular lady was working on a contractual basis in the Assam Seeds Corporation. But there was something, and she was directly appointed as an administrative officer without there being any selection procedure, without there being any advertisement. I had lodged a police FIR at that point of time in 2017. If your lordship will see that FIR, I have filed a copy. Your lordship will come to page 28. Page 28.
Hmm.
This is a FIR lodged by me in 2017 against certain persons, against the person who was in the helm of affairs at that point of time, and this particular lady who had got the job without there being an advertisement or any regular
But
recruitment.
was it registered?
Yes, this case has been charge sheeted.
Okay.
Now, I have enclosed that also. I had asked for a response from the Commissioner of Police, and your lordship will come at page 31. This case has been charge sheeted against her.
Okay.
This case has been
Page
charged.
31.
Yes, this is the information that I have received from the police.
But you have lodged the FIR against her and against the person on the helm of affairs.
Because I
Any
thought
other
that
person?
he must be the person who has given her the appointment.
But Sasip was not laid against him.
This person, lordship, I am told lordship, he has expired in the meantime. But there is a charge sheet and which was submitted on 13/11/24.
Page.
Page 31, lordship. Page 31, the last sentence, lordship.
Okay.
So now this is the prelude. Now, lordship, the office chamber of this particular lady is under CCTV surveillance. Immediately after the incident, she went to the managing director. I also went to the managing director, and in fact, the managing director, in front of the managing director, she apologized, said that I lost my temper. Managing director told her to supply decent copies of the information, and if there is no information, at least write that. I have stated that in my petition, lordship. And this incident happened on 9th, lordship. Very next day, she turns around and files this FIR against me. So, lordship, I am praying, lordship, at least I may be protected, lordship. In fact, after
Case
filing,
is under investigation.
in fact, after filing of the FIR, the police issued me a notice. I visited the police station. My statement has been recorded. There has been no further, anything has gone. If there is anything, lordship, I should be picked up. I should be put in prison, but not like this, lordship. My humble prayer at this stage is, lordship may call for the
See, if I call for a CD,
lordship.
as it is, you won't be arrested.
As on date, I am not arrested. And in fact,
I
my
won't be arrested if I call for the CD. Without granting you stay, I can call for the CD.
lordship, no, for your lordship satisfaction, if there is any further investigation, because I was called for 2 days. In fact, the first day which I was called, the IO was not there. I was asked to come on the next day. I went
This
there.
is a obscene, uttering obscene words. and
Lordship,
this type of
Lordship, if
petty offences. I
if
think.
if that is true, lordship, if there is anything has happened, it will be recorded in the
In the
CCTV. It is an office, lordship.
But not in the chamber. In private chamber, no one will keep CCTV.
Yes, it is there. My information is, my client says it is there. It is there. Therefore,
chamber.
yes,
This is-
therefore, I have made a statement in my petition also. If I have done anything, it will be recorded in that CCTV, lordship.
I'll call for the CD.
Lordship, and in the meantime, lordship, no further, lordship,
Coursive action.
no pursuit
What do you
action,
say?
lordship.
Yeah, this is
Can,
the CD.
can be granted. Third learner, Mr. P.T. Chaudhary for the plea. The debt does, no?
Yes, lordship.
Notice was served to him, annex for 7/27 case.
Yes, I attended, lordship. I attended.
That submission may be,
All right.
There are
You
two notices,
remind
lordship.
me, I may forget.
no.
There are two notices, lordship, NHS 6 and NHS 7. 26 and 27,
Page 26 and 20.
27. I attended, lordship.
First file is application for section 558 of the BNWS 2023. Challenging, you are challenging the entire FIR,
Yes, lordship.
challenging the FIR registered as dispute PS case number so and so sections. Part Mr. D.P. Goswami, learned at Assam. It is submitted on behalf of the rights of behalf of that an FIR was registered. That the FIR, that the aforementioned FIR was registered against the petitioner with allegations of misbehaving with allegations of uttering obscene words inside the office in a public place, i.e. inside the office chamber, as well as other such allegations. It is further submitted that the prelude to an FIR is two RTI applications marked as Annexure 1 and
Annexure 3.
Annexure 3.
There are two
the
RTI
petition,
applications.
Uh,
And the orders passed by the State Commission are at 2 and 4.
marked as Annexure 1 and 2, no?
1 and 3 are the
1
applications,
and 3.
and 2 and
the
4 are the orders of the
Orders passed
State
by the
Commission.
State Commission of RTI, no?
Assam Information Commission.
Assam Information Commission, marked as Annexure 3 and 4 of the petition. It is submitted that information was sought from the petitioner, sought by the petitioner, but the respondent number 2 refused to disclose any information as sought for by the petitioner. The petitioner had to appeal against the order of order rejecting information, full stop. Finally, the commissioner directed the respondent number 2 to furnish information to the petitioner, which the petitioner again refused, despite the direction from the commissioner on the appeal preferred by the petitioner. Respondent refused to provide information. Thereafter, an FIR, thereafter, for it is against the allegation of
Lordship,
miscon-
after After the commission in the second appeal passed an order to give the information within 10 days, they did not give, then I filed a complaint before the commission.
Oh,
There's a
okay.
provision for filing
FIR
a.
not. After the
Complaint.
information was not provided, then
I filed a
it-
complaint before the,
a complaint was filed by the petitioner
before the Assam Information Commission.
Before the Assam Information Commission.
And the Information Commission fixed, directed the respondent to give the information within 7 days and fixing the matter on 23/4/25. In connection with that, Lordship, I was asked to collect the information for which I had gone to the office.
When the Information Commission was submitted, when the Information Commission asked the petitioner to collect the information, the petitioner then went, within 7 days, the petitioner then went to the office. And then this false FIR and these DHESC, these false allegations have been brought up against the petitioner on the date of the incident. Full stop. It is further stated that earlier in the year 2017.
In 2017, I had filed an FIR.
The
Before
petitioner
the-
had filed petitioner had lodged an FIR against the respondent number 2 and another person who was at the time of affairs. And charge sheet was laid against the petitioner. Full stop. Annexure.
Annexure 9, Lordship, you'll find. Charge
Nine
sheet
is
by
the
dispute
sheet
PS case number so and so dated 13/11/24.
Of dispute PS case number. Annexure 9, no? Page 31, no?
31.
Section 9 is the report of the charge sheet of dispute PS case number 812 of 2024 dated 13/11/2025. File submitted against the petitioner. Full stop. I have considered DP उसमें लिखिला नहीं. I have considered the submissions at the bar. The learned petition PP has submitted that notices have been issued against the petitioner and the petition, and this also submitted on behalf of the petition that the petitioner has appeared before the IO on issuance of notices.
Yes.
2 times it was issued.
2 times he has appeared, Lordship.
One is,
He has appeared more than that, Lordship.
It appears that the charge sheet, the case diary is necessary, call for the case diary. And meanwhile, no coercive action to be taken against the petitioner.
and issue notice also. The respondent number 2.
Yes.
Also, issue notice to the respondent number 2, returnable within 4 weeks. List accordingly. List accordingly not. Data the due. We are calling the
Yes.
case diary, no?
Yes,
Then it's-
so nice, Lordship.
Item number 18. Case diary.
Lordship, I want to clear one thing. As per Learned senior friend submission, that he has appeared and set and recorded.
His submission. I have recorded that is his submission.
May I please, your lordship? My lord,
Yes,
in fact,
Hmm.
this proceeding is not the outcome of the matrimonial dispute between the husband and wife.
Husband by.
Husband and wife. My lord. The respondent number 2, she filed a petition under section 125 CRPC.
Mentioned in the page number 5, my lord, paragraph 5 and female. That the petitioner begs to state that he has approved this again before this honorable court on the following new cause of action. That no cross case had been mentioned in the first bail application. There is a cross case, my lord.
Okay,
My lord.
okay, all right. Where is the FIR?
FIR,
Earlier you didn't mention about the cross case.
FIR, my lord. C, annexure C, my lord, page 17, my lord. Cross case, my lord. Yes, 7. This is the cross case, my lord. There is a dispute between the parties on the on the land dispute, my lord, there is a land dispute between the parties. My lord. So, my lord, one party file a case against another party file the case against another party. In such way, this dispute is running, my lord. So, my lord, considering the case of the cross case, my lord, the both parties are suffering from their land dispute, my lord. And again, my lord,
This case is booked under which section?
mother of the petition is
Okay,
73
this case-
years old, my lord. She is suffering from cancer, my lord.
Okay. It's booked under which section?
My lord,
Under which
64,
section? Huh?
64, 64 of BNS,
64 will be?
64 of BNS, rep.
Yes, sir, 64. এইটো হেৰি অকৰিবলগীয়া হৈছে
rape case, my lord.
4 years, 1 month, 2 days, my lord.
Delays,
Oh, no, you will have to issue notice.
Issue notice, my lord.
my lord, in this case, my lord, the victim informant is already expired. There is no, opposition number 2 is here, only the state, your lordship. Only the state. And I have also decision of this honorable court that for the wrong committed by the council in your lordship can condone the delay. I have two judgment of this honorable court.
My lord, that is there, but my lord, at this stage, notice will be issued if they're in the next that will appear and will have to, my lord, 4 years, 1 month,
Victim has died.
my lord.
Victim woman has died.
Victim is a person, man, and
Huh?
petitioner is a woman.
Ah.
Petitioner is a woman. And there was a COVID period, your lordship. 2 years COVID period are also there from 20 to 22. COVID period was there, my lord. My lord, kindly may I refer to this judgment of this honorable court, 223, 2023, 3 GLT 832. Yeah.
Now we will hear him
Come
My
on,
because this is for
Yeah.
1 year delay.
My lord,
We'll hear him.
I have explained and I have mentioned it.
Your grounds are there in the petition.
Right.
COVID period and everything is there.
my lord.
So what he has to say, let's hear him.
My lord, as per my lord, provision of section 5 of my lord, limitation act, my lord, they will have to give sufficient cause and they will have to explain on day by day, my lord, what is for what purpose it was delayed.
But this is a statutory appeal, no?
My lord, this is the statutory represent and the day is, my lord, it is
How many
1
years in jail? Your
lordship.
punishment?
punishment
Only
is
1 month, only 1 month.
One
Asylum 1 month only.
and delay
Only
is
1 month.
1515 days.
And
1500
punishment, your lordship, fine, punishment, imprisonment or fine is there.
whatever may be, my
And
lord.
the allegation is only pushing from the chairman.
My objection is regarding that delay, my lord. They will have to explain 1515 days delay, 1515 days delay, my lord.
Well, I have annexed the,
And given the, my lord, wrong advice by the advocate, my lord, it is not the, my lord, sufficient cause, my lord, for condoning the delay, my lord. Even if 100, 200 days, it is defined, my lord, but it is 1515 days delay, my lord. Even if it is a statutory appeal, my lord. They will have to explain, my lord.
54, na?
53, your lordship.
Third learner counsel, Mr. MJ Kati,
MJ Kati.
for the applicant. Saina Begum Bormia, who has filed this application under section 5 of the Limitation Act 1963 with prayer for condonation of delay of 1386 days.
No,
1386.
1515.
Correct করে দিয়েছে, correct করে দিয়েছে, 1386. Correct by the
Yes,
registry.
400 days,
1386 হইলো, corrected,
1386 days,
corrected by the
4 years,
registry.
my lord.
4 years delay.
Yes, but my citations may be my lord considerable. Two decisions of this honorable court. In one decision, my lord, 1360 days condoned, my lord. In 2023, 3 GLP, my lord. There are 1360 days.
1386.
Once
In
this
filing
uh,
connected criminal revision petition challenging the judgment and order dated 20/03/2021.
21 judgment, Your Lordship.
20/03.
Yes, Your Lordship.
2021 in connection with criminal appeal number 66 of 2019 and the judgment and order dated
15/11/19. Page 9.
fifteen eleven 2019 passed by the learned
Let's CJM highlight.
Chief Judicial Magistrate Hailakani in connection with GR case number 821 of 2016. Wherein the appellant Saina Begum Borguia was convicted under section
448 and 323.
wherein whereby and where under the wedding number. Uh, 448 IPC to undergo simple imprisonment for and sentenced to undergo simple imprisonment for 1 month and to pay a fine of rupees 1,000 with default stipulation for and under section 323 IPC. And sentenced to undergo simple imprisonment for 1 month and to pay a fine of rupees 1,000 with default stipulation. An appeal, agreed by this order, an appeal was preferred and by the impugned judgment and order dated 20 March 2021, 20/03/2021, in criminal appeal number 66 of 2019. The appeal was dismissed and the conviction and sentence was upheld by the learned appellate court.
Well, what happened, well, in the meantime, on the advice of the counsel, the petitioner paid the fine amount, Your Lordship, because the sentence amount is not informed. She already paid the fine amount, my Lord. I have page number 36. She appeared and
It's not required, that is not required.
Yeah. I have annexed the order sheet, Your Lordship.
It is not required. You can take it up in the other case.
The revision petition.
Where is the ground in the petition?
My Lord, ground, my Lord. Page number 5, paragraph number 6, my Lord.
It is submitted on behalf of the appellant that the delay occurred due to owing to the COVID-19 pandemic during 2021 and 2022 and thereafter owing to misinterpretation of the judgment of the appellate court by the applicant and her counsel. So, the payment of fine, the case was fixed for appearance of the victim with effect from 2/5/2022 up to 26/7/2024. Most of the victim has passed away. Full stop. Thereafter, the case was fixed for death report of the victim. Full stop. The applicant was unaware about serving her sentence till the receipt of the notice from the trial court. Full stop. The engaged counsel of the applicant did not inform her about the conviction and sentence being upheld by the learned appellate court. The learned counsel for the appellant has relied on the decision of this code in connection with of this code within brackets Shillong bench bracket close in connection with Ka Bril Khar Konkar Jaid Khar we লিখি লবা হা versus so and so wherein it has been reported in 1985 1 GLR 314 which paragraph wherein it has been observed that
Paragraph 8 and 9, my lord.
paragraph 8
My lord, in another citation, my lord, 2023 GLT, 3 GLT, my lord.
full stop the
Ashish
applicant
Das.
has also relied on decision of this court in Ashish Das versus State of Assam
Paragraph 28, 29, my lord.
reported in 2023 3 GLT 832 wherein it has been observed that paragraph
28, my lord, 28 and 29.
28 and 50
Yes, my lord.
Twenty-eight
28 and 29 also.
and 29. The learned additional PP, Mr. B. Sharma has raised serious objection stating that that section 5 of the Limitation Act connotes that every day's delay has to be explained to the satisfaction of the court, full stop. 4 years delay is not justified. The applicant does not deserve any relief. I have considered the submissions at the bar with circumspection. I have also relied on the decision of this court referred to by the learned counsel for the applicant. I have taken into consideration that the appellant and that the applicant being she is educated, not educated.
My lord.
Educated, illiterate.
Yes, my lord, yes.
Being an
Village-
illiterate
village
woman
illiterate
was
village.
not aware of the procedure of the court, and she was not correctly informed by her engaged counsel. In view of my foregoing discussions, the delay is I have also considered that the pandemic also delinked many the pandemic also delinked the information what have been received by the applicant. In view of my foregoing discussions, the delay, although inexplicable, is hereby condoned. Registry to register the connected revision petition.
Of like, high level.
দুটা জাজমেন্ট এইটো এটা ঘূৰাই দিলে ভাল হ'ব নেকি এটা নাথাকে কনফিউজন হৈ যাব এই দুটা থাকক এই দুটা মই ক'লো
Item number 25.
Lordship, my senior legs in another court also.
All right. Your senior will
Senior
come.
is appearing in another.
Item 26.
Wait, period, Your Lordship. Well, it's a second bail application, my lord.
Hmm.
Page 16 is the order, my lord. Page 16.
Hmm.
The operative part, my lord, page 17, paragraph 5, my lord.
Hmm.
The FIR affords that the informant booked a road carriage via Siliguri, Kolkata road line, Tinsukia on so and so, and the road line provided a good carriage track number so and so of Ashok Leyland motor registered in the petitioner's name. Accordingly, the truck was loaded and driven and brought to Tinsukia. The load was to be delivered to one Jafar Ali at Goroimari, Kamrup, rural. The load was so and so green battle nut amounting to rupees 5,08,000. The truck commenced its journey on so and so at about 6:30 p.m. from Tinsukia. After 11 a.m., the phone numbers of both the driver and the handyman were found switched off, and the truck was not traced out. On inquiry, the truck was found at Sagolia, Dhubri, without the load, and the owner of the truck was trying to change the nameplate and the color of the sticker, etc. But that was the gist of the case, and that was rejected by a lordship. My new ground is, my lord, at page 19, my lord. In fact, my lord, I have, my lord, given this track to my lord, to my driver, my lord, by a notarization of notarized, my lord, later, my lord. That is at page 19, my lord. Equivalent to driver. Yaqub Ali is the driver, my lord. Page 20, my lord, lordship will see. I, the undersigned, is the registered owner of the above vehicle, do hereby authorize the above person to drive the said vehicle on road and hand over the vehicle along with the relevant documents to the above authorized person for driving the vehicle on road as per MP Act. I do hereby undertake to declare if things happen at any time at anywhere in India during the plying of the vehicle, the above mentioned driver will face and maintain all the matter, that is the motor vehicle department, police, CRP, army, court, whatsoever office in India. This fact was not brought, my lord, at the time.
But that the owner was trying to change the nameplate.
My lord, that lordship may call for the up-to-date case.
Yes,
diary.
I will.
My lord, I am not facing it.
Not for the up-to-date case diary, list the matter on.
Tinsukia.
Time lagega.
Duty.
I will take a chance, man.
Standing item 24.
Wait, please. This is an application under 528 of the BNSS. It's for questioning of the FIR and charge sheet. But you will kindly have the FIR at page 15, 15. This is Annexure 2.
This number से दिया मिल बना है ना?
Yes.
Yes, my lord, if I may read the same, my lord.
Yes.
This is the FIR. Vinithu Nibodin is a Guwahati Panjabari Road, house number so and so Nibaki Parizat Soikia, which is this petitioner, my lord. Namor Podokia Zono Logot, Jua 28-10-20 ইংৰাজী তাৰিখে মোৰ AS 19 so and so JCB SK water খন মাহে 1,20,000 টকাৰ এক বছৰৰ বাবে এগ্ৰিমেণ্ট কৰি লৈ মোক সময়মতে ভাড়া আৰু গাড়ীখন উভতাই দিয়া নাই লগতে 4 মাহ বেছিকৈ ৰাখি মোক so and so 1,000 টকা দি বাকি টকাখিনি আত্মসাৎ কৰে এতিয়া মই পদকীয়াৰ ওচৰত পাবলগীয়া টকাখিনি বিচৰাত মোক দাবী ধমকি দিয়ে লগতে মোৰ মোবাইল নম্বৰ ব্লেকলিষ্ট কৰি দিয়ে গতিকে মহোদয় so this is the my lord FIR and after the FIR my lordship will kindly note one aspect of the matter. Agreement pertains to the year 2020. FIR is filed, my lords, on 1/9/2023. This is the first aspect of the matter. Second, my lords, this FIR springs out of a agreement between the parties. This petitioner used to work as an authorized signatory in a company, my lords, namely JC Lang Construction Private Limited. That work order out of which it has sprung out, that I have annexed at page 22, my lords. And the contract, my lords, took place, the agreement was signed, and the entire work took place at Nagaon, my lords. nothing to do with Bongaigaon, my lord. And this work order is dated, my lord, 30th of October 2020, regarding the work to be done by the JCB, my lord. And your lordship will find pages 22, 23. my lord.
Where, which page?
22, my lord. This is the work order, my lord, which was entered into by the parties. Here, lordship will find the vendor's name and address, Biki Kundu. Biki Kundu is the informant, my lord. And the delivery address, this is Messrs. JC Lang Construction Private Limited. I used to work in this company, but I am not director or anything, never was. And lordship will also find quotation number and date, verbal discussion dated 28/10/2020. So this is the my lord's agreement between the parties, out of which this FIR has sprung out. Now, if your lordship will also have the page 24, my lord, as to what is to be done if there is any dispute between the parties. Clause 15, my lord, 1.5. Governing law. This agreement work order shall be governed by and construed in accordance with the laws of India and under the exclusive jurisdiction of courts at Guwahati, Assam. My lords, agreement took place. Agreement was signed at Guwahati. Work took place at Nagaon, and the FIR has been filed, my lord, at Bongaigaon. This is the second aspect of the matter, my lord. Now, lordship will kindly have page 26, which is the pre-arrest bail that this petitioner had obtained, my lord, from this honorable court. The coordinate bench, my lord, of this honorable court had granted me absolute bail. And the observations, if I may say so, my lords, at page 27, the last para onwards. In view of submissions of learned advocates of both sides, and also in view of materials collected so far in the case diary, as well as the progress of the investigation, and also in view of the cooperation being extended to by the applicant to the investigating agency, and also having regards to the nature of accusation, which appears to be civil in nature, further custodial interrogation of the appellant seems not warranted in this case, and accordingly interim order dated so and so is hereby made absolute in the same terms and conditions. Lord, the coordinate bench observed at the time of disposing the absolute bail, my lord, that the accusations are civil in nature. But, my lords, the police has filed its charge sheet on, my lords, my lord, 30/11/2023. That is at annexure 5. Lords. And if I may take your lordship to the charge sheet, my lord, which is virtually a reproduction of the FIR, the lordship will have page 33. 33, the last panel. During investigation, I have examined the complainant and victim and witnesses and recorded their statements under section 161 CRPC. I have also visited the PO and drawn the sketch map so and so. In the course of investigation, it comes to light that on 28/10/2020, the complainant's so and so number JCB SK Water was signed by agreement for 1 year at 1,20,000 with the accused Parijat Suikia. The accused spent 4 months more and handed over the rest of the money by giving a total of 774,500 rupees. Then another day, the accused Parijat Suikia signed in the written paper for 1,50,000 rupees of the amount due to the complainant, and the remaining amount will be paid later. And it came to know that the accused Parijat Suikia was accompanied by 2 other people, namely Devendra Nath Sharma and Langpoklang Joychandra Maitei from JC Lang Construction Private Company Limited Company at the time of signing the said contract. Although the accused Parijat Suikia took all the responsibility and signed the contract himself. After interrogation, the accused Parijat Suikia released on bail as ordered by the Honorable Interim Pre-Arrest Bail Order of Guwahati High Court. The sufficient evidence found against the accused person Parijat Suikia during investigation, prima facie case is found well established against under section 420 IPC against the accused, namely Parijat Suikia. So I submit CS against the involving accused person for his involvement in the offense. So and so kindly release the alleged accused, namely Devendra Nath Sharma and Langpoklang Joychandra Maitei due to insufficient evidence. Well, the charge sheet is virtually a reproduction of the. There is neither in the FIR nor in the charge sheet anything regarding the dishonest intention of the accused at the very inception, which is a sine qua non, my lords, for section 420. Now, my lord, the lower court has taken cognizance and the date is fixed tomorrow. So I pray that my lordship will issue notice and my lord stay the proceeding before the lower court.
My lord, here, first of all, we'll have to go to the my lord, FIR, my lord. My lord, first of all, page number 15, my lord, FIR, my lord. Here is the specific that Parijat Suikia, my lord. He is taken as JCB, my lord, for 1,20,000 per month, my lord. It was my lord, supported by PDO 22, my lord, page 22. It is the work order, my lord. 22, my lord.
Yes.
Here, it is the vendor's name and address. That is Biki Kundu. Biki Kundu, my lord. And later part, my lord, hire search for JCB.
Hmm.
Month 12, rep unit rupees 1,20,000. Then, my lord, here and the later part of my allegation is that, my lord, টকাত 1 বছৰৰ কাৰণে এগ্ৰিমেণ্ট কৰিলে মোক সময়মতে ভাড়া আৰু গাড়ীখন উভতাই দিয়া নাই লগতে 4 মাহ বেছিকৈ ৰাখি মুঠ 7,74,000 টকা দি বাকী টকাখিনি আত্মসাৎ কৰে এতিয়া মই পদকীয়াৰ ওচৰত পাব লগা টকাখিনি বিচৰাত মোক দাবী ধমকি দিয়ে লগতে মোৰ মোবাইল ফোনটো ব্লেকলিষ্ট কৰি ৰাখে my lord here after investigation my lord police has submitted charge sheet my lord finding some materials against him, my lord. Although bail is different matter, my lord, here it is the quashing of the my lord FIR and charge sheet, my lord. It is also different aspect, my lord. Bail is granted, my lord, only saying that FIR, my lord, only discussing about the FIR, my lord. And here it is the quashing of charge sheet, my lord, FIR and charge sheet, my lord. But in the investigation,
Will call for the will not grant it.
my lord.
My lord, if the trial progresses, then my lord, this will become infructuous. And the very, my lord, then I'll have to rely on certain judgments of the apex court and of coordinate benches. Lordship will, I'm not saying Lordship may fix a small date, a short date, my lord, and service may be through court. This is a matter in which the criminal acquisition arises from the agreement. If I have not paid a certain amount, then, my lord, where is the dishonest intention? I can agree it may not be there in the
Yeah, he has taken it for 1 year.
My lord.
Yes.
Then
4
after
months
that,
more than that, my lord.
4 months more than
investment,
that.
no?
Has,
Yes,
my lord,
it is
has any
1
civil case been filed, my lord? Matter pertains to 2021. Today, my lord, we are in
But he
2020.
was waiting for 1.5 years.
But my lord, I have repaid the most of
One
the part.
1 year, 1 year, 1 month, he
Why
has
not?
given paying and thereafter he has stopped paying.
Why not?
Again,
That is
4
it.
months continuous.
Yes, 4 months continuous.
So
But that is
they-
that is the allegation in
they
the
were
FIR.
waiting-
Lordship.
They were waiting because there was an agreement.
Yes, that is they have an agreement, and there is also the fact that I have repaid a substantial amount of this. That is made out by the my lord's police.
For the vehicle, you have retained the
Yes,
vehicle.
no, I have returned the vehicle. There is no that
No,
is the
but
it's a,
here allegation is you have retained the vehicle.
my lords, it is my submission may be recorded. The vehicle and 11,24,000 rupees already returned. That I have said to the given the statement before the police. That is why, my lord, the case diary is very important. Lordship may call for the case diary and the charge sheet, my lord, and the my lords, record of the lower court, and give a short date. And my lords will Lordship may fix a date and say that it will be disposed of. If it be so, my lord, then my lords, absolutely we'll proceed. But
My lord,
the fact is that once, my lord, I start appearing there, matter, my lord, will be infructuous.
Lordship may fix at this stage notice may be issued and call for the record, my lord. And interim may be considered after receipt of
My lord,
record, my lord.
interim may be considered, no, that is, it sounds very nice, my
Sure.
lord, but it is never granted. My lord. What I say is that the short date may be fixed before the vacation. We will take whatever steps your lordships think fit, my lord, and by service by any way permissible service if necessary to the OC concern.
Let us stay because he has returned the vehicle.
I have returned the vehicle.
Return the vehicle, my lord. In a FIR itself, it is said that return the vehicle, but
Yes.
the remaining amount, my lord. Remaining amount,
What could you say?
my lord. Remaining amount,
Vehicle,
my lord.
vehicle.
My
ইমান
lord,
টকাত
at
1 বছৰৰ কাৰণে এগ্ৰিমেণ্ট কৰিলে মোক সময়মতে ভাড়া আৰু গাড়ীখন উভতাই দিয়া নাই
What idea নাই, no?
নাই
Like-
লগতে
this
4
is
মাহ বেছিকৈ ৰাখি
2023, he is making an allegation, and when he returned the 7,74,000 with the vehicle, man.
then he has to come, my lord. He will explain, my lord, what is happening.
My lord, he will not explain. It
He
is the
will-
charge sheet which will explain and the materials.
Have you mentioned in your petition that the vehicle has been returned?
My lord, let me check.
Then he
If
will
not, my
better,
lord, my submission can be recorded.
he will better know, my lord,
My
what
lord,
is happening, my lord.
I will.
Mention that you have returned the vehicle, then there may be a ground for stay. Otherwise, you won't have any ground for stay.
Let me see. If necessary, then, my lord, I will file an additional affidavit, but it may fix it on, my lord, if it is not safe. No, it will be in the case diary because my statement is given to the police.
Then we won't stay, no? We'll get the.
Then
case
lordship
ready.
will have it day after tomorrow. I'll file the affidavit tomorrow, stating that on which particular date we will mention. We'll mention. Lordship will have it day after.
David, then it's okay.
Yes, lordship.
But meanwhile, we can call for the trial court records.
My lordship will have it on day after tomorrow. Because I am, my lord, because the matter is tomorrow. I have to place some material before.
Mr. Egangoli, no,
Lordship.
has paid for, has submitted for time to file an affidavit, list the matter on additional activity.
Four. Publish.
Pending item 23.
May I please.
Hmm.
This is an 528 application praying for quashing of an FIR, which was subsequently been compromised in between the parties. The allegation is that allegation is that his father, grandfather and uncle are the owner of a plot of
They
land.
jointly filed. Joint petition.
No joint
Not joint
petition. We
petition.
have make them the party law. Because there is a written agreement that we have annexed at page 26 here. Page 27 is 11.
Hmm.
Lordship, may I read? Whereas the first party number 4, there is all the legal has executed this agreement, has lodged an azahar before the officer in such Tinsukia PS alleging inter alia that the second party in collusion with one Sumon Sur advocate and Prasenjit Kumar Goswami Notary, Dibrugarh by preparing some false document obtained NOC for land sale and subsequently got the sale deed registered in the name of Orpana Gogoi, party number 2 of the second part in respect of plot measuring so and so, so and so, so and so. And on receipt of the said Azahar, a case being Tinsukia PS case number so and so against the party of the second part and Sumon Sur and said Prasenjit Kumar Goswami. And whereas with the intervention of common friend and well-wisher, the parties here to have settled amicably all dispute and differences among themselves, and in view of said compromise settlement arrived in between the parties, the first party number 4, Dipanjal Mahali, is no more interested to proceed further with the case. That is Tinsukia PS case number so. So at this is further proceeding may be steady.
Third learner come from Mr.
Yes, sir.
S.
Decker.
Decker for the petitioner. Petitioners, Opona Gogoi and Panjan Gogoi, who have filed this application under section 528
528
of the BNWS 2022 with prayer for quashing the FIR registered as Tinsukia PS case number so and so and
Hey,
the petitioner has drawn the attention of this court towards the written agreement executed between the respondent number 2,
Two.
who is
And-
the informant,
Yes.
and the petitioners, that they have amicably settled their dispute. To stop, there are sufficient grounds to stay further proceedings, thereby further proceedings of so and so, GR case,
No, Tinsukia PS.
Yes,
Yes.
still undergoing
investigation is going.
Investigation. Yeah.
Okay, nalage. Call for the CD likhi diya.
Fine.
Call for the CD. Meanwhile, no coercive action to be taken against the petitioners. List of issue notice to the respondent upon returnable within 4 weeks. List accordingly, na data review. CD aibo to.
Okay.
Please, Your Lordship. The second
yes.
bail application earlier rejected by Your Lordship, Your Lordship. Up to date CD may call for Your Lordship.
Call for the up-to-date serious
Case diary, up to-
case diary. Call for the up-to-date case diary. List the matter on data.
Bless.
My please, Your Lordship. Here's the IF for bail where the accused has been arrested on 7/11/2022. The accused is languishing in jail for more than 2 years, Your Lordship. 2 years, 6 months, 22 days till date, Your Lordship.
Are you ready?
No, my lord, here, POXO matter is here, my lord.
Let's go.
Basically, the case before your lordship is that the land in question is an ancestral property of the applicants. And our father executed an agreement for sale. And Milord, this sale agreement could not be executed. And they've sent a notice to us for getting them to execute the sale deed. Then I submitted a reply. I gave a reply to the effect that my daughter and son is not allowing me to get them land executed through a registered sell it. And this is also admitted in the plaint itself. But where in Millard, in the case Millard, we have not been implicated. That is one aspect of this case, Millard. Second is that we have, so far my father is concerned, Millard, he filed his written statement. But this written statement was filed after 90 days. And thereafter, Millard, he has filed an application for, then he was not allowed to, this written WS was not considered. Then he also filed an application for allowing him to consider this WS. But unfortunately, this application was not placed. Thereafter, the application proceeded, suit proceeded ex parte. And even in the ex parte agreement, Millard, then another application was filed, and but that could not be heard, Millard. No, Millard, basically, let us here should only come to the judgment itself, Millard. RFA 37, judgment is page at page 8. Got it? The case of the plaintiff in brief is that she was intending to purchase a plot of land and hearing the same, purchase a plot of land and hearing the same on 2/11/2012, the defendant approached him to purchase a plot of land measuring 1 gata 16 lesser of 16.56 lesser out of 2 bigha 12 lesser, fully described in the schedule below. After physical verification, the aforesaid land on 15/11/2012, on 20/11/12, the parties executed a registered agreement for sale, fixing consideration at rupees 27,37,500, out of which a sum of rupees 7 lakh, 7 lakh was paid as advance part payment with the condition to pay the remaining amount at the time of registration. Now, Millard, paragraph 2. It is the contention of the plaintiff that the defendant undertook the responsibility to obtain necessary permission from the authorities. But when he delayed the matter on 2/2/2013 and 12/2/2013, he asked the defendant about the progress of obtaining the permission for sale. On those days, the defendant informed him for him to wait for few days, because although he submitted the application seeking permission for sale, but the office of the Deputy Commissioner Dibrugarh and Dibrugarh Development Authority were delaying the matter. Hearing this information, he visited on the two offices, but he found no such application on behalf of the defendant. Similarly, on 31/3/2013 and 4/4/2013, the plaintiff made the defendant asking him to proceed to produce the permission for sale and to execute the sale deed, but of no fruit. Lastly, on 13/5/2013, he sent a notice through his lawyer asking the defendant to execute the sale deed. In response to that notice on 16/5/2013, the defendant replied that his sons, this is very much important, that defendant replied, it is specifically stated, replied that his sons and daughters did not agree for selling the land him because their own accommodation thereon. For the time being, Lord, the land in question is our ancestral property, that we are guided by the Mitaksara law. And the moment, and these son and daughters are the grandson of the original landlord. So they acquire the right title interest over the plot of land by virtue of their birth. So they have opposed their father not to execute this sale deed. And this fact is also admitted in the plaint itself to the effect, at least not by saying so, that this land in question, that the defendant is guided by the Mitakshara law. But one thing that has been admitted, that due to the hindrance caused by the daughter and son, he was not in a position to sell this plot of land. And now, Milord, he instituted a civil suit. And in that civil suit, we were not implicated. We means myself and my daughter, my sister, who are the daughter, son and
Son
daughter.
and daughter were not pleaded.
We are not, no, we were not implicated. And that is the sole problem here, because of non-impediment, Milord.
Okay.
Now, Milord, what happened? Our father filed his written statement, but unfortunately,
Yes, yes. It was not allowed, not accepted.
not
After 90
accepted.
days, it was not accepted.
And it is not accepted. Then, Milord, the proceeding, the case proceeded ex parte. And at the time of argument, before the time of argument, Milord, we also filed, our father also filed another application. But it was not allowed because of the fact that we had not prayed, our father did not praise it. This is the key. And as a result, the matter went ex parte. Look, I have two aspects of this matter, Milord. I would like to place before your lordship to get ourselves implemented in this case, to establish to the extent that we are necessary part. And in our written statement, Milord, also, written statement means our father's written statement, we have also stated that your lordship will find at page 29.
Of the RFA or the application?
Yes, of RFA.
Page 20.
Just to satisfy your lordship that we are necessary part. No. Now, paragraph 3, state where your lordship come to paragraph. The suit is bad for non-gender of parties. That is the surviving legal heirs and successors of the defendant as per the procedure of Mitakshara law. That was specifically stated, Milord. And Milord, here the land is not our self-acquired property, not the self-acquired property of my father. This is our ancestral property. To that effect, Milord, a statement was also made to the effect that it is our paternal, the land in question is our paternal property. Now, as the written statement could not be filed, now your lordship come to paragraph 15 of the written statement. The page 31, the contents of paragraph 8, 9, 10, 11, 12 of the plaint are denied by the defendant and the plaintiff is put to the stricter proof of the same. In this content, defendant submits that the plaintiff undertook the responsibility to convince 3 sons and 1 daughter of the defendant to obtain their consent. That was our case, to obtain their consent in getting permission to execute the sale deed, but till date no steps taken for the purpose on the part of the plaintiff, and hence the question of any kind of delay in execution of the final sale deed does not arise. Now, Milord, I would like to place 2 judgments, Milord. We put about binding time. 2000. Enough for a night together. So far, Mitakshara law is concerned, Milord.
Lord,
I want to say one thing here. So for implement of the party, if my learned friend can show that they are really interested, your lordship can so much to implement them even
Yes.
without any application. And the law is abundantly clear on that, that is in 2017 3 SCC 194. Now here in this case, your lordship will find, the hard fact of this case is that there are 3 sons and 1 daughter. And 2 of the sons, one son committed suicide because of this case. Because I'm telling the true facts of this case. He bargained with his father that you don't sell it because since we're governed by the Mitakshara law and the land belongs to all of us. So all alone, you do not have the power. So in that view of the matter, these people are all necessary parties. And without going into the nitty-gritty of the thing, at this stage, my lord, it's up to your lordship because my learned friend has shown from the written statement and all that they are necessary party. And the fact is that 2 of the sons, my lord, they died. One got out of depression, my lord, ultimately he died out of an accident. And another, my lord, he was also went through depression, ultimately committed suicide because of this land. And then present son and daughter, my lord, they are also having all this mental anxiety. And God knows what happens to them. Now, till now, my lord, they are holding their nut. Under that circumstances, my lord, the fitness of the case, what I feel, let them say what they want to say. If they can establish their case, they are governed by the Mitakshara law. And if the land is, my lord, in the realm of Mitakshara law and all that, and if it is their ancestral property, let it be established, then let the thing can be adjudicated in a one go. Otherwise, my lord, this is the fact of the case, what happened in the past, my lord, I am stating with your lordship, so that the further damage in the sense of, my lord, committing suicide and all this can be stopped. Because what I realize that they are still suffering, and the present son, he is also suffering from depression. The daughter is also suffering from because of this fact. So this is what I want to say at this stage.
Yes.
My lord, I am the respondent number 2, my lord.
You are the plaintiff.
Yes, and I am the decree holder, my lord. In the IA, my lord, I am the respondent number 2 and the decree holder, my lord. Mr. Adilur Rahman Sadian. My lord, your lordship will find in the IA, my lord, in paragraph number 5 and 7, my lord, of our objection. We have objected to it. Para number 5. May I read, your honor?
Yes.
Of my objection.
Yes, you can.
Page 5, para 5. That with regard to statement made in paragraph number 4 and 5 by the petitioners. That is with regard to Mitaksha school, my lord. I am objecting, my lord, specifically. Para 5. That with regard to statement made in para number 4 and 5 by the
In the
petitioners.
in the IA, no? In the IA.
The IM. In the IA, we have,
Just a
yes.
Page number 4, no?
Yes.
Para 5 to page 4.
Para 5.
Para 5.
Page 4, no?
May I read it, your honor?
Anyway,
Yes,
4 or
yes.
5, whatever may be.
Yes, yes.
That with regard to statement in para number 4 and 5 by the petitioners in the instant IA are not at all correct. Therefore, OP number 2 denied each of the statement amendments made in the said paragraph by the said petitioners. More particularly, the said sentence that the plot of land mentioned in the decree by the trial court is the ancestral property of the petitioners of the opposite party number 1. And all are governed by Mitakshara Hindu law of inheritance. As per Hindu Succession Act 1956, is fully denied by the opposite party number 2 herein. In this regard, the OP number 2 submits that the petitioners herein have no rights to get themselves implemented in the connected RFA number so and so, as they were nowhere parties. Lordship, kindly note this, they were not the parties in the title suit number so and so,
which was decreed by the civil judge Dibrugarh in favor of the plaintiff OP number 2. Moreover, the rights of the petitioners arises only on the next page, that of their father, but the petitioner's father, who is joined as OP number 1 in the interlocutory application, is already alive and is an appellant in RFA number so and so, now pending before the Honorable Guwahati High Court. It is astonishing to note that when the connected RFA was about to be disposed of, kindly Lordship will knows this was fixed earlier for hearing, was about to be disposed of by the Honorable High Court, but the petitioners herein have filed the instant IA, whole of the hearing of the RFA number so and so. Although at no point of time it was decided as a joint property, nor there is any evidence on record. But to frustrate the decree dated 12/3/2018, passed in title suit so and so, the petitioners have unnecessarily filed the IA. Thus, the prayer of the petitioner to implicate themselves in the RFA number so and so is opposed by the OP number 2 herein, as it would cause great prejudice to the OP number 2. And further, at the appellate stage, kindly Lordship, the word is appellate stage, the petitioner could not join as appellant to start a new cause of action, which is also not otherwise permissible, and the prayer for their impleadment may be rejected by dismissing the so and so. Now your Lordship will come to the agreement, my lord. I have annexed the agreement. Next subpara, my lord. It is to be submitted that time is essence of the contract, which is specifically appear in the contract agreement dated 2011-2012 between the plaintiff and the defendant to sell a plot of land measuring 1 katha 16.12 lisa out of land measuring 2 katha covered by DAG number so and so or periodic patta number so and so described in schedule of the agreement and in the plain. Now your Lordship will kindly note the plaintiff OP number 2, this is a decree holder, my lord, have paid a part consideration amount of rupees 7 lakh. I have already paid towards the consideration amount of rupees 27,37,000 so and so in the year 2012, my lord, with due acknowledgement by the defendant OP number 1. And as per clause 5 and 6 of Exhibit 1 agreement, it is the defendant who was duty bound to take necessary steps for obtaining sale permission from the concerned authorities, which is not complied till today. On the other hand, the defendant OP number 1, your Lordship will note this very important matter, played fraud upon the OP number 2, who took rupees 7 lakh as per agreement to perform the contract of sale, as it is a personal property of defendant OP number 1, who have already sold, Lordship will kindly see here, already sold one part of land measuring 15.44 lisa to one Neelam Devi. This is part of the decree also, my lord. In the year 2015, out of DAG number so and so, by taking money from her. And this is indicated that the defendant OP number 1 have committed breach of trust with the plaintiff OP number 2 herein. Hence, on considering the entire conspectus of the issue involved, the learned civil judge Dibrugarh in title suit so and so have passed a judgment and decree on 12/3 in favor of the OP number 2 herein, and further permanently restrain the OP number 1 from alienating the suit land and from creating any charge thereon. In the aforesaid circumstance, the present IA may be dismissed. Now your Lordship will come to that person who the defendant has sold the one plot of land to Neelam Devi solely by him without the sons and daughters. Lordship will kindly come to page 10 of the judgment, appeal memo, RFA. Just one paragraph, my lord.
Okay.
Page 10 and paragraph number 6, my lord, or the RFA. Here it, my lord. Para 6, Mr. K.S. Islam, learned counsel appearing for the plaintiff, referring to the document submit that the next page, document submitted by him will prove the authenticity of the pleadings made by his client. Referring to exhibit number 6, with a shocking state, he submits that the defendant who took a sum of rupees 7 lakhs in advance from the plaintiff in the year 2013 sold out a plot of land measuring 15.44 lisa to one Neelam Devi in the year 2015, and this indicates that the defendant committed criminal breach of trust with the plaintiff in the premises aforesaid. He prays for declaring the suit, allowing relief prayed for. Now your lordship will come to page next 6.1 judgment, my lord. My willingness to, my lord, to perform the contract under the specific relief act. Mr. J. Khan, learned counsel for the defendant, submits that executing the agreement in between the parties, receive of a sum of rupees 7 lakhs, that is admitted, my lord, by them, as advance, as well as serving of the legal notice and the reply thereof are all admitted. Kindly note, my lord, all are admitted. He submits that the defendant was willing to sell the suit land in favor of the plaintiff, but in the meantime, the wife of the defendant expired, and due to providing accommodation to his son, he wanted to retain the property. In the premises aforesaid, the defendant prays for passing necessary. This is the thing, my lord. There is nothing whisper. Lordship will kindly say there is no whisper or supported by any instances to show that previously, my lord, these are joint family property, my lord. Joint family property, there is nothing in this case to show any documents, my lord. Now your lordship will kindly come to my objection, where I have annexed the, my lord, agreement for sale registered. Page number 12 of my objection, my lord.
So according to you, they cannot be implemented because of the.
They are the third party, my lord, in my humble submission.
They are third party.
They are third party, yes, in a suit for specific performance. And they are, my lord, lordship will note one more point. They are not the part of the agreement, registered agreement, which I have annexed. Page 12 of my objection. Exhibited document, exhibit 1. They are not part of this registered agreement for sale dated 2011-2012, my lord. Kindly note, my lord, from 2012 they are holding the money, my lord. So they are not part of this agreement, and this is a case for specific performance agreement where, my lord, the third party cannot be implicated. And moreover, my lord, this, my lord, the applicants, present applicants, my lord, in the IA, the legal hires and so on, my lord, they have not performed anything in pursuance to the agreement. They have not performed, neither they have done anything in pursuance to the agreement. Now that has attained finality, my lord. Thus, my lord, I have a short judgment, my lord, to support my argument, my lord, regarding Order 1, Rule 10 petition, my lord. My lord, I am relying on a short judgment, my lord, regarding Order 1, Rule 10 petition filed by the applicants, my lord. Your lordship will kindly come to paragraph number 2 of my judgment. That is Sudammai Patnaik and others versus Vibhu Prasad, my lord. 2022, my lord. Kindly come to paragraph number 2, my lord, and para number 5, my lord. Para number 2, your lordship will find that was also an application filed under Order 1, Rule 10 for implement of subsequent purchasers as party defendant during the pendency of the suit and after evidence was over. But here, my lord, your lordship will kindly see para number 2.1, 2.2, and 2.3. The said application was opposed, my lord, on the ground that dependent 1 to 4 have no locus standi. to file such an application. It was also the case of the plaintiff that the plaintiff are the dominus litis, my lord, the word is used, and nobody can be permitted to join implead as defendant against the wish of the plaintiff. That was the case. By order dated 22/2019, my lord, learned civil judge allowed the said application and directed the implead the subsequent procedures. It was allowed in civil court. Now, against that, my lord, Supreme Court, High Court also allowed, and in Supreme Court this matter came. In para 5, your lordship will kindly note what is the observation, my lord. We have heard learned counsel for the respective parties at length. Para 5, my lord.
Yes.
At the outset, it is required to be noted that the defendants in the suit file application under Order 1, Rule 10 CPC and pray to implead the subsequent procedures as party defendants. The suit is for declaration, permanent injunction, and recovery of possession. As per the settled position of law, the plaintiff are the dominus litis unless the court suo motu directs to join any other person not party to the suit for effective decree and for proper adjudication as per Order 1, Rule 10 CPC, nobody can be permitted to be impleaded as defendant against the wish of the plaintiffs. Not impleading any other person as defendants against the wish of the plaintiff shall be at the risk of the plaintiff. Therefore, subsequent procedures would not have been impleaded as party defendants in the application submitted by the original defendant, that too against the wish of the plaintiff. That was rejected, madam. And in our case, while already decree has been passed, during the trial also, they have never showed anything that this legal hires did something in terms of the agreement, my lord. And
No. They have submitted written statement.
they have submitted written statement, my lord, but they have their evidence, they have not let any evidence, no record of that they are the legal hires or they have performed anything.
Yes.
Our thing is that this is a registered agreement, my lord. We have came for specific performance of the agreement. We have paid 7 lakhs to them. That is from 2012, they are holding it, my lord. And later on, my lord, they have sold one portion of the land to one Neelam Devi in para 6 of the judgment we have stated, my lord. And that is a breach of trust, my lord, they have committed. And now they have come, when that is the stage of hearing, my lord, the applicants have come showing that it is a Mitaksha school of governed by Mitaksha. So my submission is that, my lord, Mitaksha school of law is not applicable even in Assam also, my lord. Even in Assam also
Not
not.
applicable. But they are saying no.
They are saying, my lord, but this is not based, they are not supported by any, my lord, provisional law that it is applicable in Assam, my lord. That is the thing, that is create another cause of action, my lord, my submission. That Mitaksha school of law is not applicable. And that too in a specific relief act, my lord, it is not applicable. And I am relying on that judgment only, my lord. Supreme Court judgment, my lord. And I pray your lordship may dispose of this IA and entire matter may be fixed for hearing, my lord.
I'd like to refer 3 paragraphs of my the written statement.
Then
Now,
you have read, no?
Huh?
That you have read. I have also apprised him.
no,
that
paragraph 3 I read. Paragraph 11 and paragraph 14.
You have read, no? You have read.
You also
those
read?
paragraph. Yes. You read it.
Here, my lord, it is specifically stated that we are governed by the Mitaksha.
Yes. You have read it.
Now, if we are, and if it is an ancestral property, definitely, my lord, we acquire some right by birth. Now, your lordship, just one judgment I would like to refer you, your lordship, that whether the petitioners have a right on their ancestral property or not. And second thing that I would like to say, Lord, the argument put forward by my learned friend that Mitakshara law is not applicable in Assam, probably it is not correct. Because Mitakshara law is a Bengal school of law. It is applicable in Assam as well as the Bengal. So far the rest of the country is concerned, Dayabhaga law is the Bengal school of law. It is applicable in the state of Assam and as well as the Bengal. And so the rest of the countries is concerned, they are governed by the Mitakshara laws. So that is, it is known to everybody, beloved. Now, let's just, I would like this judgment, beloved, 2020, volume 9, SSC, page 1. I just only refer to 1 or 2 paragraphs, beloved. It starts from paragraph 18. I will like to read only one line. The Hindu branch of Dharma is influenced by the theological tenets, the Vedic essence. Let us keep it up. Now, there are 2 main schools at page 32. 1, 2, 3, 4, 5, 6, 7, 8, 9. There are 2 main schools of Hindu law, that is Mitakshara and Dayabhaga. Got it?
Page?
Page 32, 32.
Yes.
Paragraph 18.
Yes.
Historical background. Last but 2 lines. There are 2 main schools of Hindu law, that is Mitakshara and Dayabhaga. Mitakshara has further been subdivided into 4 schools: Banaras, Mithila, Maharashtra, Bombay, and Dravida. Madras schools, Banaras, Mithila, Dravida, Maharashtra denote the old names of the old territories. So let us keep it up. Then your lordship come to paragraph 22. Proportionary and joint family property, my lord. Joint Hindu family is a larger body than a Hindu proportionary. A joint Hindu family consists of all persons lineally descended from a common ancestor and include their wives, unmarried daughters. Joint Hindu family is one in worship and holds joint assets. After separation of assets, the family ceases to be joined. Mere severance in food and worship is not treated as a separation, as observed by such and such, such and such. Now, paragraph 23 and 24 and 25 are some important. Right? Hindu proportionary is much older. So we are Hindu proportionary because this is a property of our grandfather. Hindu proportionary is much narrower body. It consists of propositions and 3 lineal descendants. Before 2005, it included only those persons like sons, grandsons, and great-grandsons who are the holders of the joint property. For example, in case A is holding property, B is his son, C is grandson, D is great-grandson, E is a great-great-grandson. The proportionary will be formed up to D, that is great-grandson, and only the death of A holder, the property of the right to A would depend proportionary is confined 3 lineal descendants, since grandsons, great-grandsons become the proportionary by birth, they acquire the interest of the property. So if the property was, the owner of the property was our grandfather, then by dint of our birth, we acquired a share. Now, paragraph 24, proportionary property is one which is inherited by a Hindu from his father, grandfather, or great grandfather. Property inherited from the others is held in his rights and cannot be treated as a forming part of proportionary. The property is proportionary is held as joint owners. Paragraph 25 below. The proportioner shares get rights by birth. This is very much important. Another method to be proportioner is by way of adoption. As earlier, a woman could not be a proportioner, but she could still be a joint family member. But by substituted section 6, with effect from 9/9/2005, daughters are recognized as proportioners in their right by birth in the family like a son. Proportionary is the creation of law. Only a proportioner has the right to demand partition. Test if a person can demand a partition, he is a proportioner, not otherwise. Great grandson cannot demand a partition as he is not a proportioner. In a case out of 3 male descendants, one or other has died, the last holder, even the 5th descendant, can claim partition in case they are alive and he is excluded. So this is some elaborate discussion on so many paragraphs. The gist of this, my argument is that this is an ancestral property. My father, it is not my self-acquired property of my father. So by virtue of our birth, we acquire our right. My sister has also filed an application before this honorable court, Miller, to get herself impleted. Now, basically, Miller, even if we do not consider our written statement for the time being, then also, Miller, from the plaint itself, it appears that because of the son and daughter, the sale deed could not be executed. He gave a legal notice, and in that legal notice, my father specifically stated that my daughter and son is not allowing me to sell this lot. That is his pleaded case even. So what prevented him to implead myself or my sister? I don't know. Had it been implemented, then it would not have occurred. And second thing is, Miller, we have, our father also filed a written statement, but unfortunately, this written statement could not be considered because of the fact it was filed beyond 90 days.
Okay, then.
So this is my precise case, I think.
Just one, I'll take just one. My lord, as my learned friend has said, Mitakshara law is not applicable in Assam. My lord, it's absolutely wrong conception. My lord, this honorable court in a division bench judgment has stated, supposing, my lord.
Applicable for the party is governed by the school. It will be applicable.
Exactly, my lord, I'm stating that, my lord. Supposing I have come from Bihar and I'm living here in Assam. Now, my personal law will be the same.
Not from Bihar.
That Mitakshara will be applicable here. So as my learned friend is saying that Mitakshara law is not applicable in Assam, is not correct at all. That conception is totally wrong. My lord, I'll tell you, I will give your lordships 2 judgment of this honorable court. My lord, today it's not possible. Tomorrow I'll furnish those 2 judgments. There is one is 2009 4 GLR 106. Another is 2008 4 GLT 234. That has been emphatically stated that if one migrates from some other place, because there are 2 schools as the lordship is aware. One is from the Bengal school, that is Dayabhaga, that is applicable in Bengal and Assam. And apart from that, other parts of the country, they are governed by the Mitakshara law. That is well accepted by
2009 4 GLT.
2009 4 GLR, page 106. And this is the same judgment, and equivalent is 2008 4 GLT 234. So there is no confusion at all that a person migrates from Bihar to Assam, my lord, the Mitakshara law will be applicable. There is no doubt about it. Apart from that, my lord, your lordship is hearing a matter, implead the necessary party.
necessary
And
parties.
when my learned friend Mr. Dasgupta has to some extent possibly could highlight that they had a relation in this aspect of the matter in regard to the property in question. Now, in fact, my lord, I am not siding anybody. My lord, I am, so far the legal question is concerned, is an ancestral property governed by the Mitakshara law. And these two legal heir were ousted, they were not made a party. And then my learned friend also argued that they are not party in the agreement. No, my lord, if the person, my lord, the appellant has not taken their consent and on his own he has made the agreement, this agreement is void ab initio, because if it is a governed by Mitakshara law and you don't take their consent and make an agreement, it has got no value. So in that point of view, my lord, the application which has been filed, after all, my lord, your lordship is not discussing about merit. So let them be a party, your lordship can hear it its entirety to adjudicate the matter in the precise way. That's my submission. And
The end matter,
some other decision, my lord, your lordship can note, 2015, volume 15 SCC, 567, that has said even at the appellate stage, your lordship can implement them as a party. Then another, my lord, that is 2017, 3 SCC, page 194. My lord, the court can so much to implement them as a party if your lordship thinks.
17,
2017, 3 SCC, 194. Then, my lord, your lordship can note 2007, 10 SCC, page 82.
you've given this.
Yes, if a party can show a semblance of interest, your lordship can implement them as a party. That's all, my lord, your lordship kindly see that. Well, can I hand over this decision tomorrow to your lordship?
I have 2007 SSC, 2007 10 SCC 82. Then I have, you have given already.
Then 15 SCC.
You have given me 2029 SCC.
Yes.
Page 1.
7
These two you have already given.
All. God bless.
And my lord, I have relied one judgment, my lord.
Hmm.
I have given one citation.
Yes, yes. I have kept it. You have heard Leonard Senior, Mr. A. Das- Leonard Leonard Mr. Item number
50.
50 na? B. Boru,
B. Bora for OP number.
order OP number, respondent number 2. Reserve for reserve for order. I you know. David. Stanley.
God bless.
Yes. Item number 8. Item 29. Order Nikki. Appellant is not represented. This term. 1 week,
No, it's
please after 2 weeks. Item number 30. 22.
Please, your lordship.
Yes, it.
I verified the opposition of 29.5 by order dated 5/2/24. Case diary was called for in the LCR receipt, but it is not there.
CD is not there.
LCR corporate is not record.
It's
Next week,
reminder and
next week we'll fix the date, the urgencies. Trial is going, there is no stay order.
Scan copies of the trial court record are received, but the CD has not been forwarded. Call for the scan copies of the CD, leave them later on.
Next week, any date.
Next week, we have 10th of June.
Publish.
May I pray, dear Lordship? Lordship, I am praying for Jimma of my vehicle, your Lordship. My vehicle says due to carrying some cattle, your Lordship. FIR is page number
My lord,
11.
I have received a report, my lord.
Just a moment. Charge has been submitted.
My lord.
Charge has been submitted.
No. Yes, that's it. Not I have submitted, my lord. Yes, CD is also available with us, my lord. And report also received, my lord. The report, my lord.
If I am the registered owner, your Lordship.
A vehicle number
Vehicle number,
6855.
Lordship, I have annexed RC page number 23, your Lordship.
My lord, along with my lord here in the vehicle, my lord, 2 numbers of heck number plate also recovered. Clear. And later part it was said that my
Rejecting it.
my lord.
I'm
Lordship, I am already appeared before the IO, your
So
Lordship.
that is different thing, my lord.
Lordship, I am the registered owner of the vehicle. I have no knowledge. My driver running the vehicle,
CD
your
is with
Lordship.
him. CD is with him.
And
My
in the
lord, CD
meantime, I have
It's a CD, I have the report. Not now. You come after a few days. At present, I'm registering it. Third learner counsel, Mr.
M. Hussain, your Lordship.
M. Hussain. On behalf of? Okay, Mr. M. Hussain, on behalf of the petitioner, Baharul Islam, who has filed his application under section 528, review section 438, 442 of the BNWS 2023, read with article 227 of the Constitution of India, challenging the order dated 23/12/2024 passed by the learned chief judicial magistrate. Should you wait or should I reject it? See, you cannot file revision petition again.
Quite, your Lordship.
Huh? I'll
Wait.
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 I'll wait there.
My lord,
Or
here.
should I dispose it?
At my disposal of my lord, here we have received the report, my lord.
All right.
And he is also opposing grant the Jimma, my lord. At this stage.
2024 passed by the learned chief judicial magistrate Moregaon in connection with I Jimma petition number 4156724 rejected the prayer for petitioner for Jimma vehicle. Is in connection with so and so PS case under so and so sections. Heard Mr. B. Sharma, learned additional PP Assam, who has raised serious objections stating that they are incriminating materials in the case diary against the petitioner. The vehicle seized in connection with this case bearing registration number AS 01 RC page what?
Lordship,
What is your vehicle number?
In the last para, my lord,
Say double
13 perhaps. Yes, 13. I also oppose for my lord, 13. Jimma at this stage.
Was seized in connection with this case with several number plates. Full stop. It is submitted that the
Lordship is
petitioner was deeply involved in smuggling of cattle and manipulating number plates. I have considered the submissions at the bar with circumspection. It is submitted on behalf of the petitioner that the petitioner was not involved in smuggling cattle. He was not aware that his driver and intimate.
no, your Lordship. He is the registered owner of the vehicle. He has no knowledge
being
about the carrying the cattle, your Lordship, by his vehicle.
activities.
In the meantime, he is already appeared
He is
after
smuggling cattle by his vehicle.
granting interceptive bail, your Lordship.
The report I have witnessed the report forwarded by the IO. At this juncture, it appears that there is no illegality or impropriety in the order impugned by the petitioner. In the order impugned by in the order passed by the learned CJM Morigaon and impugned by the petitioner. In the wake of the foregoing discussions, I am not inclined to grant JIMA of the vehicle at this stage. Send back the CD.
Well.
The report is kept with the record.
Well.
The report of the IO is kept with the record. In terms of the above petition state.
On item number 29, madam. There
Oh,
was
bless
an
you.
IA, madam, NDPS commercial entity, madam.
Oh, that
Yes.
criminal appeal.
Yes, that matter may be the hard and dispose of finally, madam.
Okay.
Can it be fixed for hearing, madam?
Itu PSL
Learned
learned Dr. Mr. S.
the months of June by July.
For the appellates to list this.
No, the second week of
Yes,
June,
we
madam.
admitted, no.
Yes. Second of LCR is also there, madam.
Matter has already been.
We have filed our objection also.
Any date on second June, madam, second week of June, madam.
It has not been admitted.
But record is there, madam.
I know. It has not been admitted, but there's no order. I'll admit it.
Yes.
Learned as the present for the appellate. Appellate. Justice. The appellant has preferred this appeal against the judgment and order dated 30/07/2024 passed by the learned special judge additional Dhubri in connection with special case number 179 of 2023 arising out of Gulubganj PS case number so and so under 190 of 2023 convicting the appellant under section
22C,
2C of the NDPS Act 1.
10 years.
Rigorous imprisonment for 10 years and fine of rupees.
That is.
One lakh with default stipulation. Appeal is admitted as the LCR is already with us. List this matter for hearing
Second week of June, my lord, any day.
on date of the detail.
12 June. Highly obliged.
Complete for you.
In item 31, we will return back the case there. 31 already disposed of.
Send back the.
Right.
This is a first appeal, my lord. It may be admitted.
First appeal against
Against judgment and decree dated, my lord, 25/2/2025, dismissing this suit filed by the plaintiff, my lord.
insurance.
Insurance claim. Because some contract work has been insured with the insured company, flood insurance, and that was proved also.
Money
that-
that you pay security.
My lord,
You pay security. This is a money suit.
to dismiss, my lord.
Oh, so has been dismissed. So it has been dismissed, not paid.
Okay.
Learned counsel, Mr.
SK.
SK Ghosh is present for the appellate, who has preferred this appeal against the judgment and order dated.
Judgment and decree dated
Judgment and decree dated
2025.
passed by the learned
Civil Judge, Senior Division, Tinsukia, in money suit number 25 of 2011,
dismissing the suit
dismissing the
of the appellant. Use the memo of appeal. It appears that appeal lies against the impugned judgment and order. May issue notice to the respondents 1 and 2. As per usual process, returnable within 4 weeks. Call for the trial court records. List accordingly.
That's
Item 34.
This matter, your lordship, it had come up on the last Wednesday. My lord may remember that It is with respect to the plea of juvenility. I was convicted under section 10 of the POXO Act, my lord. But in this appeal, my lord, I have raised the plea that I was a juvenile at that particular point in time. So, my lord, I am only praying at this stage that the lordship may issue notice to the respondent number 2. However, your lordship may also direct the learned.
You home, observation home,
No, my lord,
special home,
No,
you are on bail.
I'm not on bail, my lord. I'm in jail, my lord. And
Okay,
the
you
plea
are
of juvenility was not
you are
raised,
adult now.
my lord.
You are an adult, but you want to take the plea of juvenility.
Yes, my lord. That plea was not taken during the course of trial. I've attached the document, mainly the school certificate, my
In the
lord.
IA,
Yes, my lord.
we'll take up the IA first then.
Notice may be issued, my lord, POXO matter, my lord. This is, oh, my lord.
POSCO?
My lord, POXO, my lord.
IA लिखी बापा.
My lord, there is one judgment that I wanted to show your lordship also wanted to see that.
Where a notice.
Not necessarily, my
No,
lord.
no.
It is only for notice, my lord.
No, just
After hearing.
only that the provisions of the Juvenile Justice Act will override every other act. So if the plea of juvenility is allowed, then all the provisions of CRPC or POXO Act will not apply. So that is why, in fact, this had happened in this case, my lord. So,
My lord, they have taken the plea at this stage only, my lord. At this stage, my lord, here,
That your supporting judgment is relating to
during the,
state
my lord,
during appeal or
appeal, my lord. In the IA.
after conviction
Yes, yes.
after conviction, my lord.
while disposing of the IA.
Yes, my lord. My lord, may first see para 3. First para 3.
17.
By the interlocutory application being IA.
No. You see, that time that notification was not in force. 2025, 2023 notification, 23 and 24 notification. That one, that notification to issue notice, it was not in force.
Yes, yes. That notice, I have the judgment also, Deepak Nair, my lord. That judgment was based primarily on section 439(1)(a) of the CRPC, my lord. And read with the POXO Act. However, in this judgment also it is stated that
No, see, we already have a notification in force, no, now.
lordship, I have no objection towards issuing notice, but
That's the issue because people are waiting also.
My lord.
There are many people waiting. I don't know, their matters will be left over.
lordship, may fix a date in that case.
Let them appear, my lord, thereafter.
After notices and all, we will consider
My
this.
lord.
We'll give it back to you.
Lordship.
To write it. Learned counsel, Mr.
Yes, they, ma'am.
As there is present for the applicant. First of applicant to take steps to issue notice to the respondent, learned additional PP, Mr. B. Sharma is present for the respondent state. A notice to respondent returnable within 2, 3, 4 weeks, because it is coming from Tinsukia. 4 weeks?
Slightly shorter date, my lord.
There is a written short date. 26 June, because he is a juvenile, according to you. Appeal to rule, yeah. Okay. Call for a. This can be admitted.
My lord. Fine.
Appeal to admit, appeal, admit, call for the child court records. After notice, respondent number 2, returnable within 26 June.
Much of like.
May it please, sir. Also, this application has been preferred for quashing of an FIR, more particularly Goreshwar PS case number 51 of 2024, which has been registered under section 108, your lordship. Now, on the last occasion, case diary has been called for, your lordship. FIR is at page 15, your lordship.
My lord, yes, there is.
Now, FIR is of 26/8/2024, and till the charge sheet has not been filed, your lordship. Page 15 is the FIR, your lordship.
108.
My lord.
What is
Abatement to switch it.
Huh?
Abatement to switch it.
Page,
Page 15 is the FIR. It may I read it, Your Lordship.
it's okay, I'm reading it. What do you have?
My lord, we have received the case diary, my lord. Here, my lord, it is from the case diary, my lord. It is not a case of my lord passing, my lord. Here, petitioner number 1 is the husband, my lord. Petitioner number 2, 3 are in-laws, my lord. And from the statement of the witnesses, my lord, it reveals that they are all of them, my lord, mental, physical torture, my lord, for which he is committed suicide by poisoning, my lord, by consuming poison, my lord. Here, from the FSL report also, it was revealed that, my lord, and exhibit so and so gave positive test for paraquat disolite, which is a herbicide. By consuming herbicide, from the witnesses, my lord, it was reveals, my lord. Well, I have flag mark, my lord, here.
Permission of orders.
It's for admission, my lord. And perhaps notice also not included, no? Which party gonna, no? Their allegation is against all of them, my lord. And even the in-laws, my lord, they are trying to, my lord, ফুটবল চন্দ্ৰ বড়োই বিবাহ বিচ্ছেদ কৰাৰ বাবে স্বামী সোমনাথ বড়োক উচতনি দিয়াত সোমবাৰ বড়োই শাৰীৰিক ও মানসিক অত্যাচাৰ কৰে, all of them, my lord. Even they have forced husband to divorce her, my lord. That are also available. Difference, all the witnesses, independent witnesses are also there.
No, otherwise, Your Lordship, I have stated in paragraph 2 of my petition, Your Lordship, the basic fact of the case is that the deceased person, she was in a relationship with another person. And when it came to the knowledge of the petitioner number 1, that is the husband, it's everything got started at that point of time, and she consumed poison, Your Lordship.
But they are out of CD, my lord. Their statement, my lord. Lordship, page 1 to statement, my lord. Independent witnesses are.
This is your praise for washing their hands.
Passing of the FIR.
This is at the stage of investigation.
Yes, Your Lordship. In fact, all the petitioners has been granted bail by this honorable court, and they have appeared before the IO.
No, they have not stated anything about illicit affair. Only that she used to fight. Have you got anything about illicit affair? No.
Why not?
Accused have not stated anything about illicit affair.
No, no, no.
Only that she used to fight.
No.
This is the allegation.
This is the allegation.
No, they have not said anything about
No.
illicit affair. Cannot be quashed. I'll
Fine.
reject the petition.
Okay.
Third learned counsel, Mr.
T. Bodley.
T. Bodley for the petitioners. একটু pronounce করবো পারেন। SWMKHWR, Chandra Bodo, Subhan Chandra Bodo, and Satya Chandra Bodo, who have filed this application. 528 of the BNWS 2023, with prayer for quashing the FIR registered as Guresor PS case number 51 of 2024 under section 108 stroke 80 of the BNWS 2023. And Mr. B. Sharma, learned election PP Assam, who has raised serious objections stating that there are incriminating materials in the case diary against the petitioner. The victim, Kuisali Boro, was impelled to commit suicide due to the cruelty extended to her. The statements of the witnesses clearly implicates the petitioners. This is not a case of quashing the FIR, considering the gravity of the offense. This case cannot be considered to be a case which will be an abuse of the process of the court. Per contra, the learned counsel for the petitioner has submitted that the victim had committed suicide as she was caught red-handed indulging in an illicit affair with another person. As he was embarrassed, she committed suicide without any inducement from any quarter. I have scrutinized the case diary and I have considered the submissions at the bar with circumspection. I have considered the gravity of the offense. I have also considered the gravity of the offense. At this juncture, possibility of conviction does not appear to be remote or bleak, as investigation has not even commenced and charge sheet has not even been charge sheeted. It cannot be preempted at this juncture that there is every possibility of acquittal and further proceeding will be an abuse of the process of the court. I have also considered the gravity of the offense. At this stage, there appears to be no justified ground to quash the proceedings against the in the wake of the foregoing discussions and considering the submissions, there appears to be no justified ground to quash the FIR. In terms of the above observation, this petition stands dismissed and
Return the paper.
Item number 36 of the hearing.
My please, Your Lordship. This is such case, Your Lordship, and the petitioner is in custody for 719 days as on date, Your Lordship. There are altogether 7 rounds of witness.
Regarding item number 36, 37, 39, 41. And 46. In these items, the arguments will be same, Lordship, because all are regarding round of arrest, Lordship, and that too prior to Pankaj Bansal, Lordship. They are always
In respect of 37 matter, 4 persons were arrested. All 3 have been granted bail by your law. Only I am remaining. And recently, your lordship.
Unfortunately.
Unfortunately. Recently, your lordship granted bail. on 16th of May,
But now they have come up with the Pankaj Bansal's case and they have a valid argument.
my lord. That was asked on that date only. That date is earlier, my lord. I have asked.
I have yet to pass the orders.
In so
I think within 6 I'll pass all the orders.
My lord, my submission is that in respect to item 46, there is another view is plea is different. In item 46, my lord, the
No,
person
he's not talking.
he is
about
also talking about
46.
46 also. He mentioned my lord 46 also. 46, my lord, the person is about to in custody since last 4 years, 3 years, 8 months. And my lord, your lordships repeated 2 orders passed for expeditious trial. But unfortunately, 1.5 years have gone. PW number 5 have not been examined.
Do we have time today?
So, my lord, item 46, my lord.
I'll be confused.
Sir.
Confused. We'll need some time. Do we have sufficient time today to take up all the matters? We have a meeting also.
In respect of my lord,
I'm not feeling well also.
yes, this is right, fine. My in respect to item 37 and 46, only my lord 5 minutes submission, only 5 minutes. Because
If he is not taking the plea of section 47 notice lordship, then he can argue on the other points, other issues. lordship.
apart from section 47 or section 50 or step,
He's taking the plea.
this is right, my lord. Apart from that, my lord, these are two.
If he is taking that plea lordship and for arguing that in that perspective lordship, it will take some time.
My lord, item 37, plea of parity is there because out of 4, 3 have been granted. And item 46, my lord, prolonged incarceration. Your lordship two repeated orders for expeditious trial.
No,
But-
no. It's okay. It's okay. Now ground of parity, I have many judgments on ground of parity. Prolonged incarceration, too many judgments on prolonged incarceration in NDPS case. And now they have come with Pankaj Bansal's case and then now we have another case. Recently uploaded in the Supreme Court website, not reported as yet, but uploaded in the Supreme Court website. There is another case also. So there are too many cases. So we'll take up one by one there.
So one by
One
one.
by one.
First start 36.
And then he will submit his argument tomorrow maybe,
Yes.
because he'll take a long time.
May I interrupt, my lord? I'm sorry to my lord. 39 and 40, my lord. Well, these two persons were arrested after Bansal's case. Number 1 submission. And same forwarding, your lordship had granted bail for same
After Bansal's case.
after Bansal.
Then we cannot help you. Bansal's case can help you. Bansal's case can help the prosecution side, but after Bansal, no.
Forwarding. On 39 and 40 arrested after Bansal case, my lord. And same forwarding, my lord.
Court is already gone.
Petition holds.
41. 41.
Item number 39, my lord, it is 21.
Hmm?
Item number 39, my lord. Page 21, he is arrested on 8/10/24.
Yes, sir. Okay.
Okay.
And my lord, and 40 arrested, my lord, on 29/4/24.
Item 40.
20-094.
28, my lord, 28/0,
29.
29/04/24. 40, my lord. Judgment this, and that's Salimuddin judgment covers that.
Your lordship is already granted.
That much, my lord.
You have to say anything on 39 and 40. My lord, I am for 40. Lord.
No, this I am logo.
So regarding lordship, 40 item lordship, I will advance my argument regarding on the point of decision of Probir Broadcaster lordship, because item 39, it is after Probir Broadcaster.
Item number?
39. Because Probir Broadcaster judgment was came on 15/5/24. And 39, he was arrested on 10 probably.
And those of this
8/10. So after Probir Broadcaster.
39 to
The Probir Broadcaster judgment was delivered on?
Because lordship delivered on lordship 15/5/24. And there are some guidelines has been framed lordship. So Lordship, we cannot say Lordship that it is Lordship, we cannot overlook that judgment guidelines Lordship.
Yes, correct.
Yes, that we have to follow. So Lordship 39 regarding 39 after Probir request, I have nothing to say.
What does judgments are after probate request?
Both are arrested after
40 কেটে আছে।
Then they have a case.
39 I am appearing, madam.
You may have a case, they may also have a case.
No, 39 they are not objecting.
39 after Probir request, so it is not followed. So Lordship, I have nothing to say. But
And my lord-
in 40 Lordship, 40 but prior to Probir request to arrest,
Then he will argue that.
I will argue on that.
39 here. My lord, only point, my lord, the recent judgment which came, my lord. My lord, it's regarding, my lord,
Yes, they are recent judgment.
yes, recent judgment. My lord, interestingly, my lord, the apex court, my lord, relied upon a judgment, my lord, passed in the year 1956, my lord, of a high court, my lord. Although the judgment was of division bench, my lord, it followed the judgment of Allahabad High Court. That is reported in, my lord, AIR 1956, page 56. That may be recorded, my lord. AIR 1956, page 56, my lord. Well, the Supreme Court very rare of the rarest cases, my lord, rely the judgment
Yeah,
of
they do sometimes.
yes, my lord. So here, my lord, it's a judgment, my lord. There, my lord, lordship will see paragraph 30, my lord. So what are the grounds to be communicated? Paragraph 30 and, my lord, 21, my lord. That much.
Clear given.
AIR 1956, Allahabad 56. As for 39, he is not objecting, my lord. I leave.
I am for 40 Lordship.
I'll just pass an order for 39. 40, he will place his submission.
What is submission, Lordship? May make on earlier occasion, Lordship, and he already take time, Lordship, for.
I'm not taking time, Lordship. Today I'm ready. I'm not
Yes,
taking time.
yes, Lord.
Okay, then. Let him place his submission then. 40.
My lord, item 37, my lord, I'd like to place this order. Item 37.
37.
Yes, madam. These four orders.
Deviation 37, no?
That, my lord, granted by in prolonged incarceration, not in arrest.
Okay.
And item 46, I'll argue later, madam, after that.
39 to 8 to ভৰাই দিয়াচোন 39 to 40 একেলগে দি দিলে
40 in case of 40, similar persons has been allowed to go on bail by considering prolonged incarceration and without considering that 47 notice, then Lordship will decide that issue.
item number 40
Published, Lordship.
আৰু এইটো কেছৰ দি দিব anything else
40, Lordship, published.
37, sorry, no, 47, 37 Lordship.
for
40,
37 এইটো নাই নাই ঠিক আছে 47
47.
47
39 and 47, 37.
37, I have.
no 39 and 40
40 is a different issue.
we have taken up that
It will take it.
Published, Lordship.
ঠিক আছে
37 to 47.
এইকেইটা
41 and 47.
সিরিয়ালি মার্কিং গুলো ভালো করে নিই 36 36
Yes. In this case, your lordship, he is for 719 days, he is in custody. And altogether, there are 7 dongs of witnesses. And out of the 7, 5 has already
half. Five and six. Five.
7 witnesses enlisted and 5 have already been examined.
Yes, five have already been examined. And only the IO and the expert of the FSL, they are yet to be examined here. Yes, 18, your lordship, kindly have a look. This is the statement of the seizure.
Page 18.
Page 18, your lordship. Zafar Ali, your lordship, and he was the seizure witness, your lordship. Page 19, your lordship, I am the close part, your lordship. I am reading the close part. Police did, page 19, your lordship. Police did not call me to the house of the accused Nazmul. Prior to moving to the residence of Nazmul, I had no any contact with the police in connection with the incident case. I saw the contraband tablets in the courtyard of Nazmul along with the police personnel, other persons and the accused. I had not seen from which place of the house of Nazmul police had recovered the tablets.
How many tablets?
7.
Huh?
Altogether, there are 7 nongs of witnesses, and out of
How many tablets?
1,224 now.
Grams.
What
Tablets.
tablets, your lordship?
What tablets?
In the page 12 here. Espascor Van plus. You will see tramadol, no?
Okay.
It was tramadol, your lordship. And the number of the tablet was 1,224 numbers of tablets. Page 19, it is the statement of the seizure witness, and he has not stated in favor of the prosecution, your lordship. From his statement, your lordship, it is clear that he was. I am again reading the prose part of the PW1, your lordship. I saw the police part.
It's okay, I
Yes.
read it. It's okay, I read
The
it.
next one, your lordship, kindly see. Page 21, and he was also the seizure witness, your lordship. Page 22, your lordship, kindly see. Cross part only I am reading. Police did not call me to the house of the accused Nazmul. Prior to moving to the residence of Nazmul, I had no any contact with the police in connection with the incident case. I saw the contraband tablets in the courtyard of Nazmul along with the police personnel, other person and the accused. I cannot say from whom police recovered the aforesaid tablets. Police personnel did not search the house of Nazmul in my presence.
It's okay.
Police.
It's okay.
So these are the statement, your lordship, these are the evidence collected by the prosecution, and the evidence does not at all inspire confidence of the court for conviction of the accused, your lordship. These two,
Taking grounds of arrest also as a
the
ground.
ground of arrest is also, your lordship. I have additional affidavit I have filed, your lordship, wherein the notice served under section 50 that has been placed on record, your lordship. And in the notice, your lordship. That is page 49 of my additional affidavit, your lordship.
Okay.
So herein there is no any ground. There is no any ground which has not been informed to the relative of the petitioner, your lordship.
All right, what do you?
So my
Yes, yes. Yes, continue.
So my case is, your lordship, one is prolonged incarceration, your lordship. And the next part is the, your lordship, from the evidence, whatever collected, your lordship, from that, it is clear that the evidence does not conspire, evidence does not inspire confidence of the court for conviction of the accused, your lordship. And more so, your lordship, section 50, the notice served to the wife of the petitioner, which has not mentioned the ground
of the arrest, your lordship. So the,
You have any notice under section 58?
yes, yes. Yes, 49, your lordship.
That is 50.
49,
49 is 50,
yes.
not 58. Okay. All right.
So first ground lordship, prolonged incarceration. See, prolonged incarceration does not mean that trial has been started on 18/1/24 and today is 1st of June 25. Only 1.5 year. And during this period, 1.5 year, half year lordship, 6 witnesses has been examined lordship out of 7. The last witness was on evidence. It was fixed on 19/5/24. No, 22/1/25. The last witnesses. So lordship, after when within a year, out of 7 witnesses, 6 witnesses have been examined, then prolonged incarceration ground will not come lordship. It is well running lordship. And perhaps it is going something more faster lordship in comparison to other cases lordship. So prolonged incarceration ground will not be maintained. Thereafter lordship, the ground of section 40, 50 notice and all lordship. And this arrest was on 14/6/23.
Before Pankaj Bansal.
Because Pankaj Bansal delivered on 3/10/23. So it is before Pankaj Bansal case. So why I am pressing on Pankaj Bansal case also? Article 22 first we have to see. Article 22(1), what does it say specifically? Because lordship, we cannot interpret the Article 22 without having any specific guidelines from the Honorable Apex Court lordship. Prior to Pankaj Bansal lordship, the field was holding, it is like the lordship, Article 22, protection against arrest and detention in certain cases. No person who is arrested shall be detained in custody without being informed as soon as may be of the grounds for such arrest, nor shall he be denied the right to consult and to be defended by a legal practitioner of his choice. So this is also the meaning is that also he has to be informed so that he can protect himself and he can save his personal liberty by engaging in counsel advocate to defend him before the court. So this was the main intention lordship. Thereafter lordship, so many judgments come lordship. In one judgment lordship, I will come later on lordship, that that is a larger bench judgment of Honorable Supreme Apex Court lordship, wherein lordship that lordship I have furnished lordship. That is lordship AIR 1966 SC 1910. This is no judgment.
Okay.
Here lordship may kindly come to
Okay.
here lordship may kindly come to para 1920 21st. Or other, I will come to the judgments later on lordship, because if before Pankaj lordship, I will come to the judgments, reading the judgment later on lordship.
Indeed.
Para 20. What does it say lordship? Because this was a 5 judges bench lordship, and it was holding the field probably till date also lordship, because this is 5 judges larger bench lordship.
Yes.
20. Article 22(1) is 2 parts and it gives 2 parts from 19 lordship. We are not 19 paragraph 19. We are not concerned in this case with arbitrary deprivation of the life and personal liberty. The respondents were considered to have committed an offense of criminal trespass and were arrested and tried by procedure established by law. The only defect in the procedure was that they were unable to get assistance of counsel because of a provision of law which they claim to be void by reason of Article 22(1). I proceed to examine the question. Article 22(1) is in two parts and it gives to persons arrested in twofold protection. The first is that an arrestee person shall not be detained in custody without being told the ground of such an arrest, and the other is that he shall be entitled to consult and to be defended by a legal practitioner of his choice. So without being told. Article 22 gives a third protection, and it is that every person arrested and detained in custody must be produced before the nearest magistrate within 24. This is not, we are not concerned with this. Thereafter, Rosi may come to Rosi, the middle part, Rosi. It was.
Okay.
Seven line, but it was. It was indicated. It was further held that an arrest under warrant issued by courts almost always indicate the reasons for the arrest and require the person executing the warrant to produce the person arrested before the court. Such a arrests are outside Article 21 and 22. It was thus held that the article was designated to give protection against the act of the executive or other non-judicial authority. The case arose under the Abducted Person Recovery of Restoration Act, so and so, so and so, under such which persons abducted from the Pakistan will be rescued. So Lordship may kindly skip to the para 22. I consider that there is room for further deliberation on the point. I do not see how we can differentiate between arrest of a different kinds. Arrest is arrest, whatever the reason. Insofar as the first part of Article 22(1) is concerned, it enacts a very simple safeguard for persons arrested. It merely says that an arrested person must be told the ground of his arrest. In other words, a person's personal liberty cannot be curtailed by arrest without being informing him as soon as it is possible why he is arrested. Where the arrest is by warrant, the warrant itself must tell him. Where it is by an order, the order must tell him, and where there is no warrant or order, the person making the arrest must give that information. However, the arrest is made, this must be done, and that is all the first part of Article 22(1) lays down. I find nothing in Article 22(1) to limit this requirement to arrest by any particular kind. A warrant of the court and other order of any authority must show on their face the reason for arrest. Where there is no such warrant or order, the person making the arrest must inform the person the reason of his arrest. In other words, Article 20 means that it says its first part. So, Rosi, it is that he must be told. It is not here nowhere mentioned that he has to be informed in writing. There is no any specific guidelines is there, Rosi. There, Rosi, may kindly come to para 24, Rosi. As I have stated, already a person who is arrested get 3 rights which are granted. The first is that he must be told why he is arrested. Thus, requirement cannot be dispensed with by taking bail from him. The need to tell him why he is arrested remains still. The next is that the person arrested must not be detained in custody more than 24 hours without being produced before a magistrate. This requirement is dispensed with when the person arrested is admitted to bail. Otherwise, it remains. The third is that he gets a right to consult and to be defended by a legal practitioner of his choice. This is, of course, so while the nearest continues, but there are no words to show that the right is lost no sooner than he is released on bail. The word defend clearly includes the exercise of the right so long as the effect of the arrest continues. Before his release on bail, the person defends himself against his arrest and the charge for which he is arrested, and after his release on bail, arrest the charge is he is to answer, and for answering which the bail requires him the remain present. The names meaning what defend cannot be accepted. Hereafter, Lordship may kindly come to para 29. The next page. Again, the same thing, it has been reiterated. The Criminal Procedure Code allows the right to defend a counsel, but that is not a granted right. The framers of the Constitution have well thought of this right, and by including the prescription in the Constitution have put it beyond the power of any authority to alter it without Constitution being altered. A law which provides differently must necessarily be obnoxious to the grantee of the Constitution. There is nothing in the words of the Constitution which permits any authority to alter this condition even on grounds of public interest, as the case with the grantee's right, Article 19. Nor can we, by neglecting argument, lessen the force of the declaration to express it in terms or whittle down the meaning by a specious attempt at supposed harmony between rights which are not independent. There are three rights and each stands by itself. The first is the right to be told the region of arrest as soon as an arrest is made. The second, the right to be proceed before magistrate within 24 hours. And the third right is defended by a lawyer of one choice. So this is the main intention of Article 22(1). And this has been explained by Honorable Apex Court in 1966. This is a larger bench. So as on that, we can say that today also there is no any interpretation of this bench process. So as on that also it is holding the field Lordship. So Lordship, apart from that Lordship may kindly come to Pankaj Bansal Lordship, because we are before Pankaj Bansal Lordship, this even though we say Lordship, before Pankaj Bansal there is no any other grounds which says
Yes. Okay.
Pankaj Bansal Lordship may kindly come to the Lordship 32. Para 32. Actually, Pankaj Bansal is a suggested event. It has also been confirmed in the Bihan Kumar case also that Pankaj Bansal case is a suggested that ground of arrest is written ground of arrest. 32 Lordship. That being so, there is no valid reason. Lordship got it?
Yes.
That being so, there is no valid reason as to why a copy of such written argument ground of arrest should not be furnished to the arrested person as a matter of course and without exception. There are two primary reasons as to why this would be advisable. This would be advisable only, Lordship. This would be advisable course of action to be followed as a matter of principle. Firstly, in the event such grounds of arrest are orally read out to the arrested person or read by such person with nothing further, and this fact is disputed in a given case, it may boil down to the words of the arrested person against the word of the authorized officer as to whether or not there is due and proper compliance of this regard. In the case on hand, that the situation insofar as Basant Bansal is concerned, though the ED claims that witnesses were present and certified that the grounds of arrest were read out and explained to him in Hindi, that is neither here nor there, as he did not sign the documents. Non-compliance of this regard would entail release of the arrested person straightway, as held in V. Sethil Balaji. Such a precarious situation is easily avoided, and consequence thereof can be obviated very simply by furnishing the written ground of arrest. Very simply by furnishing the written ground of arrest as recorded by the authorized officer in terms of section 20. So, Lordship, it is as though it is suggested, Lordship, even though we can admit, Lordship, that written ground of arrest may be given advised. Is advised in Pankaj Bansal case. So, Lordship, after that, Lordship may kindly come to the R.K. Arora case, Lordship. R.K. Ramkishore Arora case, Lordship. It has come in 15/12/23 after 2 months. Here, Lordship will find, Lordship.
Okay.
Lordship, we come to para 16. Page 13. Probably. Para 16, where Sandeep Kumar Bapna, that par inquiry and ground is also discussed. Also, that part I will come to that from that judgment also. And also, we can come to para 22. Next page. Para 22, page 12 probably. Para 22. In Vijay Madanlal Chaudhary Chopra, it has been categorically held that so long as the person has been informed about the ground of his arrest, that is sufficient compliance of mandate of Article 22(1) of the Constitution. It is also observed that the arrested person, before being produced before the special court within 24 hours or for that purpose of remand on each occasion, the court is free to look into the relevant records made available by the authority about the involvement of the arrested person in the offense of money laundering. Therefore, in our opinion, the person arrested, if he is informed or made aware orally about the ground of arrest at the time of his arrest and is furnished a written communication about the ground of arrest as soon as may be, that is as early as possible within a reasonable, convenient and requisite time of 24 hours of his arrest, that would be sufficient compliance of not only section 19 of PMLA but also article 22(1) of the Constitution of India. And 23, Lordship, as discriminable from the judgment in Pankaj Bansal case, also noticing in inconsistent practice being followed by the officers arresting the person under section 19 of PMLA, this directs to furnish the ground of arrest in writing as a matter of course, henceforth, meaning thereby from the date of the requirement, from the date of pronouncement of the judgment, the very use of the word henceforth implied that the said requirement of the furnishing ground of arrest in writing to the arrested person as soon as after his arrest was not a mandatory or obligatory till the date of the said judgment. Therefore, it is more clarificatory. The submission of the learned senior counsel, Mr. Singhvi of the appellant, that the said judgment was required to be given effect retrospectively cannot be accepted when the judgment itself stated that it would be necessary henceforth that a copy of such written ground of arrest is furnished to the arrested person as a matter of course and without exception. Now it is important. Hence, non-furnishing of ground of arrest in writing till the date of pronouncement of judgment of Pankaj Bansal case would neither be held to be illegal, nor the action of the concerned officer is not furnishing the same in writing could be faulted with. As such, the action of informing the person arrested about the ground of his arrest is a sufficient compliance of section 19. So it is specifically stated prior to that, if it is not mentioned or not non-furnishing of ground of arrest in writing is not a fatal, not the faulted. So this is Lordship R.K. Arora case. Thereafter, Prabir Purkayastha, Lordship. Prabir Purkayastha again. Here, Prabir Purkayastha has laid down some guidelines. That is why I am submitting, Lordship, that after Prabir Purkayastha, we may not take that plea, Lordship. But, Lordship, even Prabir Purkayastha case also, the ratio has been adopted, Lordship. They may kindly come to the last para, Lordship. 50 and 51. 50 from the, in 49, Lordship, there are some guidelines, it has been mentioned, Lordship. So, 50 from the detailed analysis made above, there is no hesitation in the mind of the court to reach to a conclusion that the copy of the remand application in the purported exercise of the communication of the ground of arrest in writing was not provided to the accused appellant or his counsel before passing of the order remand that is.
This we have discussed in the other.
Lordship.
They know, everybody knows about this now.
So Lordship, this has also been confirmed, Pankaj Bansal, Lordship, thereafter. Thereafter, Bihan Kumar came, Lordship. In Bihan Kumar, Lordship, may kindly come to para 15, Lordship, first, Lordship. In 15, Lordship, everything, it has been from the paragraph 15, we may say that the ratio has been adopted from the Pankaj Bansal case also. Para 15, Bihan Kumar.
Yes.
We have already referred to what is held in paragraph 42 and 43 of the decision in the case of Pankaj Bansal. The court has suggested that the proper and ideal course of communicating the ground of arrest is to provide ground of arrest in writing. Obviously, before a police officer communicates the ground of arrest, the ground of arrest have to be formulated. Therefore, there is no harm if the ground of arrest are communicated in writing, although there is no requirement to communicate the ground of arrest in writing. What is required, what is stated in paragraph 42 and 43 of the decision of the Pankaj Bansal case. It may, Pankaj Bansal are suggestive that merit consideration. We are aware that in Bansal, every case, it may not be practicable to implement what is suggested. If the course as suggested is followed, the controversy about the non-compliance will not arise at all. The police have to balance the right of a person arrested with the interest of the society. Therefore, the police should always scrupulously comply with the requirement of Article 20. So, Pankaj Bansal ratio has been adopted. But even Lordship will not find in this judgment that whether that R.K. Arora, Ramkishan Arora, wherein it has been specifically stated, same constituted bench, two judges bench, wherein specifically stated that prior to Pankaj Bansal, there is no any ground of arrest.
Yes.
But that part has not been considered. There is no any discussion regarding that judgment also.
In Bihan Kumar.
There is no any discussion regarding that part. That is why my further submission will be to that extent, Lordship, that it will be per inquirum and as well as sub salientum to that part, Lordship. Regarding sub salientum part, Lordship, I would like to one judgment of Lordship, State of UP and another versus Synthetic and Chemicals Limited. If one part, one judgment is pronounced on the ratio of another judgment, and in that judgment, the one part is ignored, and one vital part is not taken into consideration, because it is the vital part that when Pankaj Bansal's judgment was being pronounced, that it has been specifically mentioned that it is a henceforth and that means it is prospective, but that part was not considered.
So there is no harm in it if you consider, because the judgment is silent.
Judgment is silent, Lordship. Even that is I am saying, Lordship, that part will not be treated as a precedent. Regarding that part, will not be treated as a precedent, and it will not go have the retrospective effect, Lordship. Lordship, may kindly come to paragraph 42, Lordship. 42, Lordship, Lordship, may 42 the next page. Second paragraph. Sales tax or purchase tax, Lordship has got it, Lordship.
Yes.
Here, Lordship, sales tax or purchase tax under entry 54 is levied on sale of purchase of goods. It does not contemplate any distinction between luxury and necessity. Luxury are separated taxable and entry 62 under entry 62, but that has nothing to do with entry 54. What prompted this submission is not clear. Neither there was any occasion nor there is any constitutional inhibition or statutory restrictions under this legislative entry, nor does the taxing statute make any distinction between luxury and necessity for living taxes. In any case, the bench did not examine it, nor did it base its conclusion on it. In absence of any discussion or any argument, the order was founded on a mistake of fact, and therefore it could not be held to be law declared. The bench further was not apprised of neither Constitution Bench decision in Hoist Chemicals versus State of Bihar, Dag and Ganga Sugar Mill versus State of UP, which specifically dealt with the legislative competence of levying sales tax in respect of any industry which had been declared to be of public importance. Therefore, the conclusion of law by the Constitution Bench that no sales or purchase tax could be levied on industrial alcohol with utmost respect fell in both the exceptions, namely rule of sub saliento and there in
This
purpose.
is not required. Why I'm saying this is not required? Because it has not been mentioned there. So this is also not required.
That is, I am submitting you. That is one.
Retrospective effect and prospective effect that has not been taken into consideration by Vihan Kumar. So
Lordship.
this is also not required.
But
So
Lordship, when normally what happens, why I'm submitting Lordship? That Lordship, when there is a judgment and precedents come Lordship, but when there is, it is not mentioned that it will come as a retrospective or perspective. If it is
no, it
silent,
has already been mentioned in three judgments
Lordship,
to be precise. So
Lordship.
here it has not been mentioned, so it will not affect it.
Lordship,
Although it has not been mentioned,
Lordship.
it will not
Then
go,
that I am
it
going
will
to
go
say,
against it.
Lordship. Because it is not mentioned about that henceforth regarding that issue.
Correct.
Lordship. And then Lordship, Lordship may kindly one more judgment, Lordship, that is Lordship, regarding par NPM Lordship. That is Lordship Sandeep Kumar Bapna versus State of Maharashtra. Lordship, here Lordship may kindly come to para 19 Lordship. Why the subsequent judgment will not be with the precedent Lordship? Because this is the subsequent judgment and it will not be precedent Lordship. It cannot be 19 para 19 Lordship. It cannot be overemphasized that the discipline demanded by a precedent or a disqualification or diminution of a decision on the application of the par incurrium rule is of great importance, since without it, certainty of law, consistency of ruling, and comity of courts would become a costly casualty. A decision or judgment can be par incurrium. Any provision in any statute, rule, or regulation which was not brought to the notice of the court. A decision or a judgment can also be par incurrium if it is not possible to co-equal or larger bench, possible to reconcile its ratio with that of a previous pronounced judgment of a co-equal or larger bench. Here it fully covers our case.
Yes.
Or if the decision of a high court is not in consonance with the view of the court, it must immediately be clarified that the par incurrium rule is strictly and correctly applicable in the ratio decidendi and not to obiter dicta. It is often encountered in the high courts that two or more mutually irreconcilable decisions of the Supreme Court are cited at the bar. We think that the inviolable recourse is to apply the earliest view, as the succeeding ones would fall in the category of par incurrium. Therefore, in Lordship, para 20, Lordship will find Lordship on that I have read out Lordship. That Lordship, when a judgment cannot be par incurrium, even though it is not discussed, that you will Lordship. In the middle part, Lordship will find Lordship. The next page. An earlier judgment cannot possibly An earlier judgment cannot possibly be seen as a par incurrium, a later judgment, as the latter, if numerically stronger only, then it would be overrule the former. If it is numerically stronger, but in this judgment or sin, Vihan Kumar judgment is not the numerically stronger. The others are thus numerically stronger, because Pankaj Bansal is there, Lordship, R.K. Arora is there, Lordship, that five judges bench is also there, Lordship. So, Lordship, numerically stronger is not the Vihan Kumar, Lordship. So, Lordship, apart from Lordship, the recent judgment has come, Lordship, though it is not reported, Lordship, that is Kasireddy Upendra Reddy. Lordship. Here, Lordship will find, Lordship, the para 27, 28, 36. Para 27, Lordship, can we come?
I haven't got the judgment. You can read it out.
The object underlying the provisions or that the ground of arrest should be communicated to the person arrested has been very succinctly explained in Vihan Kumar Supra. On learning about the ground of arrest, the person concerned will be in a position to make an application before the appropriate court for bail or move the High Court for a writ of habeas corpus Further, the information will enable the arrested person to prepare his defense in time for purposes of his trial. For these reasons, it has been provided by the Constitution that the ground for the arrest must be communicated to the person arrested as soon as possible. We have to for para 28. For the purposes of clause 1 of Article 22, it is not necessary for the authorities to furnish full details of the offense. However, the information should be sufficient to enable the arrested person to understand why he has been arrested. The grounds to be communicated to the arrested person should be somewhat similar to the search claimed by the court for the trial of a case. So, Lordship, this is sufficient.
Yes.
It has come later on, Lordship. So, Lordship, in all the judgments, Lordship, what we will find, Lordship?
You give me the judgment. I don't have it.
I will look it. In
So
all,
what about your?
Lordship,
Tomorrow we
regarding,
continue tomorrow then? Day after tomorrow we won't be able to continue. Day after tomorrow? Tomorrow no. Day after tomorrow?
yes. May I just request my learned friend to give all the citation, because I have also on section 41 is also on section 50. So if you can just give all the citation so that we can also reply.
Yes.
Yeah. No, it's not. Lordship, this matter will continue on.
Yes, all the matters will continue.
Okay.
Except two
make it
matters.
further so that it
Yes, yes.
Yes.
Yes, Rama.
Tomorrow.
Yes.
This matter was heard, my lord, item number 38, my lord.
Yes.
It was actually, the other side was also heard, my lord, and actually it was fixed for order, my lord. The Horakesno Sarkar, my lord, the bail matter and the PS.
Okay.
My lord, with regard to item number 49, my lord, executing court has already
38.
48.
48. Well, I'll go to 30. No, I am on 38. No, not that. Argument was already heard.
No, we'll continue tomorrow, day after tomorrow.
My lord, this matter will be fixed taken at tomorrow at 2 p.m., my lord, subject to Lordship's convenience. Tomorrow at 2 p.m., my lord.
We have hearing fixed at 2 p.m. Day after tomorrow.
My lord.
Day after tomorrow at 2 Korea. Day after tomorrow at 2 Korea.
item number 49 may come up on Thursday, my lord.
On
49 on Thursday.
Thursday.
Thursday, my lord. Because
Thursday.
49. Because
And these matters will continue tomorrow. All these matters will day after tomorrow. Sorry. day after-
All this means, my lord, all matters.
Because we have heard only part heard one side.
Lordship, Lordship, can you make it as part of Lordship? All the matters.
Part heard
Others,
শুনলে ভালো।
it moves.
হুম।
These all matters, Lordship.
39 or 40 বাদ দিই। এরকম নিল।
Except 37 and 39.
Huh?
37 and 39 except.
No, 37 is my matter.
39 and 40 from the same parties. I don't know, they have come
40
yesterday.
is, arrest is different also. 40 I-
হয়নি? 40 শুনিব লাগিব। আচ্ছা, ঠিক আছে।
My lord, 37 and 46, which I am taking the plea of prolonged incarceration, not arrest proceeding.
No, NJ ডক্টর কি আছে? কাইলৈ শুনিব লাগিব। day after tomorrow কৰি দিম।
By submission.
ঠিক আছে। I think we'll better take up again all the matters.
Lordship.
It is getting confusing now.